Good morning, everyone. Hello, 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 Alicia. Good morning. Good to see everybody. So, do we have a treat today? We have the trial brief. So, this was going to be what they presented at trial. It is the brief. So, we're going to go over that. We have a few other documents to go through first. They're pretty short, so they won't take too much time, but we will be going over the trial brief. Good morning, Shannon's Copper. I really won't be able to sleep some more. I've had a horrible night up since 1:30 a.m. I thought I might sleep a little now, but here I am, 6:30 a.m. West Coast. Oh, I'm sorry, Shannon. I've had some nights like that too. Since the weather has changed. It's been horrible. So I feel you, girl. Okay, so let's get started. Like I said, there are a couple of documents that we're going to go over first. We did go over a bunch of documents the other day, and this is going to be the continuation of that because there was still a few more documents and the trial brief for the prosecution and defense, because we got the defense's trial brief also, what they were planning on doing during trial. We've got that too that we've got to go over. So that's why I split it up. Now, yesterday I was supposed to do this, you guys, but Restream was down. AWS, they said, was the problem. And it put a whole bunch, Snapchat, everything was down. So hello, Nana. Good morning. Sending you big hugs and kisses. So now Restream's back up. Here we are. We're going to go over this. It's going to be that trial brief. You guys is going to be interesting. Let's see what we're going to learn there. But let's get through these first couple of documents that aren't really, I guess, that interesting. I'm just going to share my entire screen. Okay. So here we go. Please smash that like button, you guys, on the way in. It's free to do, and it brings everybody in, so we don't got to keep going back to the beginning and explaining stuff and gets us out there also in the algorithm. So now, continuation from the other day when we started going through the documents. Here's some more. This is Exhibit E. Now, I've seen a lot of fighting over keeping this document sealed, and I don't really know why, but they filed it under seal. It really doesn't tell us much. These are all, when you see this AV stuff here, these are all videos. So it's not like we can click on it and see the video. So I don't know why they were so adamant about putting this stuff under seal, but here we go. So this is Exhibit E, defendant's fifth supplemental response to discovery under seal. Transcripts obtained by the defense. They give the Bates number here. Blaker interviews with Funk and Chapin and Wood. An interview with Professor Snyder, an interview with, or this is a video. So I shouldn't say interview, but I'm assuming that that's what it is. Professor Snyder, Anastasia Hurt Moran, Flavio Alvarez, Nayang Ko, another one with Nayang Ko, Aubrey Scott, Robert Eller, Rich Bitoni interview with Ava Wood, same person with Braden Paulo, with Braden Jensen, with Bethany Funk, and Kennedy Fitzgerald. That's it for this document. Like I said, when I said it's going to be quick, these first few documents, it's going to be quick. Okay, so this is Exhibit 4 in support of objection to state's motion in limine regarding the AT&T timing advance records. Now, if you remember from some of the other lives that we did going over a lot of this stuff, the advanced timing records is something that they use in the cast reports, I believe, where they're going through all the cell phones and stuff like this. And the advanced timing records are from the tower. But those records are only available for 7 days. If they don't get this within 7 days, then these records are gone. It's not like the other records that they have from the towers, right? Like where his phone would ping off the tower and stuff like that. This is something totally different. We went over this in another video, so you might want to go back and look at that video. And what happened here is why they couldn't get it is because it was like over a month later when they arrested Bryan Kohberger. So to go back and ask for these advanced timing records back then for Bryan Kohberger, they were already gone. They only keep them for 7 days, right? So comes now Bryan C. Kohberger by and through his attorneys of record, and he hereby files under seal Exhibit 4 in motion of their objection to the state's motion in limine regarding the AT&T timing advance records. Exhibit 4, certificate of authenticity of records, FBI report from S.A. Balance, and screenshot of records provided to the defense. So this is what they are arguing against. We don't have this record. It's still sealed. So whatever this Exhibit 4 is, I believe it's still sealed for whatever reason. There are a bunch of records that were supposed to be unsealed that were not. For whatever reason, they are remaining sealed. And I know a lot of them are the gruesome photos and stuff like that. So I get it. But there's also a lot of records, too, that are still sealed that were not unsealed. Okay, so this is Exhibit S1. We've heard a lot about this Exhibit S1. And I'm just going to skim through this quickly because it is repeated on the next page with the defense's answers to this. Okay, so the state's first supplemental request for discovery and disclosure. They want the defense to answer these questions that they still have. And like I said, I am just skimming through this quickly, you guys, because on the next page, you will see these same questions. I'll show you with the defense's answer to this request. See, All written, so this is the defense's reply to the state's first supplemental request for discovery. You'll see number one, all written reports, handwritten or typed, notes, scoring sheets, behavioral observations. And that is what is right here. All written reports, handwritten screenshots, behavioral observations, psychological data. So that's all repeated again here. Okay. So this is the defense's reply to this here. Let's go over it. Records from forensic psychiatric evaluation by Dr. Eileen Ryan. So that's why there was so much fighting over this S1 exhibit. So in the black is going to be what the prosecution is asking, and what is in blue is what the defense is replying. Hello, Git. Good to see you. So all written reports, handwritten or typed notes, scoring sheets, behavioral observations, and psychological data collected in the in-person forensic psychiatric evaluation of Bryan Kohberger on October 20th, 2022, October 20th to 22nd, 2024, and January 2nd to 4th, 2025. We went over this, a lot of this in the previous video I did, you guys, a couple days ago, maybe 4 or 5 days ago. Some of the other documents that were released with these, where the prosecution, we seen their motions to do more testing and stuff like that on them. We seen what kind of testing was done with the MMPI and all that. I tried to explain it the best I could there. So if you haven't seen that one, go back to the first one. So the defense replies, Mr. Kohberger produces notes written by Dr. Eileen Ryan throughout her evaluation process of Bryan Kohberger. That's all they say about it. The prosecution wants all documentation and materials, audio, video, notes, and summaries from the group family evaluation conducted on November 29, 2024, with Michael Kohberger, which is his father, Mary Kohberger, which is his mother, and Amanda Kohberger, which is his sister. And what I find here is, where's Melissa? His sister Melissa, right? And this is just a note. All their names in this family, except for Amanda and Bryan, start with M. There's Michael, Mary, Melissa, Amanda, and Bryan, right? Anyway, she says there were no evaluations of family members. However, Mr. Kohberger produces notes from the meetings. In-person individual evaluations, they wanted that with Mary Kohberger, his mother, from November 30th, 2024. Amanda and Melissa. So there's Melissa. His dad is left out here. The defense says there was no individual evaluations. However, Mr. Kohberger produces notes from the meetings. Phone and video interviews with Mary Ann Kohberger, a follow-up call, Allison Ackerman, a Zoom meeting, Ellen Trexler, January 9th, a phone call, and Dr. Ellen Novick Cohen, a FaceTime. And defense replied, Mr. Kohberger supplies interview notes from the meetings. Like, they don't say much at all. They say as little as possible. And I find it funny because in their requests, it's like paragraphs, right? But when they're replying to the prosecution, it's like very little. Number 5, all investigative materials replied upon, including audio, video recordings, Bryan Kohberger's educational and medical and mental health records, and any other third-party documents relied upon during the evaluation. The defense replies, materials relied upon were provided in discovery to the state on January 9th, 2025. Obviously, there are other documents that the prosecution knows are out there that they haven't given. And it doesn't look like the defense is going to be forthcoming with them. Hello, Charlotte. We just started, hon. So you haven't missed the best part yet, which is right after this here, where we're going to go through the state's trial brief, their case in chief, and then the defense. And you're going to see how different the defense's is from the prosecution's. So then they asked for all of this. Okay, so they want the neuropsychological evaluation materials from Rachel Orr, all raw data. You can read through this if you want. We've really gone through this before, but they're asking for it, right? They want the WAIS 5 subtests that were administered. They want the WRAT 5 subtests. And this isn't part of the MMPI, but it is different testing that they do to see what kind of education level, reading, writing, stuff like that, to see what kind of level that he's at, because they're trying to say that he had some kind of learning disorder, right? And ADHD and all this. So this is what a lot of this is for, to see, you know, what his education level is, what he understands, reading, writing, all kinds of stuff like this. Gambling they did like a huge amount here of testing on him. Wow. So I'm going to just scroll through it. This is really in depth. The Connors Continuous Performance Test. I'm not sure what this one is here, the California Verbal Learning Test, and all these tests, the testing, it not only sees his level of understanding of different scenarios and words and stuff like that, and how advanced he is with speaking, understanding the English language, and all kinds of stuff like that. It also, how can I put this in one group? You can't, but it's like his understanding of things, how he puts things together. Like if you see something, but you know something different, how do you decipher which is the truth out of that? If somebody's telling you the sky is blue, but you see the sky is red, how do you find the truth in that, in the matter of that, and how do you analyze it and stuff like that? That's what all of this stuff is. How focused you can stay on certain things. And I'm telling you, with anything for criminal law, I think he was hyper focused because it was something that really interested him, like more than a normal student. If you can understand that, it's almost like he was hyper focused on certain aspects of criminal law and the understanding of how things work in the criminal justice system. I'm telling you, from going through the schooling and 30 years experience in criminal law, I can tell you that there is so much boring crap. And it seems like with him, and so I'm talking like as a student while I was going through school, it was like, oh my God, I can't wait for this section, especially like the British North American Act and, you know, stuff like that. It's like interesting, but a lot of it was boring. But he seemed hyper focused on just certain aspects of the criminal law and criminal justice and how things worked. So a lot of this, like especially like with the autism and stuff like that, and they were also saying something about ADHD and stuff like that. I don't know how he got through that if they're trying to say that this is what he has, because I had a hard time, and I don't have ADHD or autism or anything, and to be hyper focused the way he was on certain aspects, it just baffles me. But anyway, per stipulation, Dr. Orr will transfer testing data directly to the state's expert upon receipt of identification and transfer protocol. So she doesn't want to just hand it over to the prosecution. What the defense is saying here is our doctor, our expert will give it to your expert. We're not handing it to you, Bill Thompson. We'll hand it to your expert. So she didn't want Bill Thompson seeing this stuff, I guess, for himself, which he's going to see anyway. But it's just like, we're not sending it to you until you tell us what expert you're going to use to go over this to debunk it or rebut it or whatever. I don't know. It's just weird. All scoring reports, percentiles, scaled scores, and norm references used in interpretation. So the rating scales and inventories, Beck anxiety inventory, the Beck depression inventory. Sorry for the cough, you guys, can't help it. All right, hang on a sec. You know when you feel like you got something stuck in your throat, and if it would just come up, you could stop coughing. That's what I'm doing. I'm going to take a Halls in a minute. Anyway, the behavioral rating inventory. This is all stuff. The Beck anxiety, Beck depression inventory, behavioral rating. Those go hand in hand with the MMPIs 1 and 2. Connor's adult ADHD rating scales. That's a totally different one. Social responsiveness scale, that a lot of that is covered in the MMPI 2. Adaptive behavior assessment, that is covered a lot in the MMPI 1 and 2. But it seems like they did individual testing on it for some reason. Autism diagnostic review revised. So they did all of this testing on them. Like, you guys don't understand how long it would take to do these testings. This is like hours and hours, over days, maybe even weeks of testing. I'm just getting myself a Halls here so you guys don't have to hear me hacking away. And it's funny because somebody in the comments said, "Stop smoking, have another cigarette." I've got a friggin' cold, and it's from, like, we are cold here. We're near the 0 mark, and it's raining and it's damp, and then it goes like to 78 degrees, and then the next day it's down to 0 again. That's how people get sick, and that's what's happened. So, plus I can't have a cigarette while I'm reading, or I would, believe me. So there you go. So keep commenting about my smoking. Go ahead. I'm trying to quit. So keep up with your rude comments. It's very helpful. Per stipulation, Dr. Orr will transfer testing data directly to the state's expert upon receipt of identification and transfer protocols. So again, they're saying, we're not giving it to you, Bill Thompson. We'll give it to your doctor. Number 3, they're asking for the original completed forms, observer, informant names, scoring data, interpretation manuals, or computer-generated results were applicable. The interview documentation, the examiner's handwritten and typed notes, all recordings of interviews in person, phone, Zoom, FaceTime. Documentations, now I just swallowed some of this. Oh, Oh, okay. Documentation of the dates, locations, and durations of all interviews with the defendant and collateral sources. And defense replied, interview notes are disclosed herein. No testing data otherwise exists other than disclosed in requests 1 and 2 above. All materials used to form the basis of clinical opinions and or conclusions. All materials relied upon for the basis of opinion and conclusion is disclosed through the disclosure of testing data and interview notes. All other materials were disclosed in the defendant's discovery response on January 9th, or discovery materials supplied by the state and noted in Dr. Orr's written reports. But they don't have Dr. Orr's written reports, right? That's why they were asking for it up top there. Any interpretive guide, scoring software output, or standardized references consulted? And they replied, they're getting a little bit better with their replies here. The interpretive guides and scoring software input are subject to copyright and not reproducible. So in other words, they're saying, we can't send it to you because we can't copy it. It's copywritten. Like, this is a court. You know what I mean? Like, these are documents for court. They are available for purchase directly from the test publishers for qualified professionals. In other words, she's saying, We're not going to show you the guides, the scoring software, or the standardized reference charts because it's copywritten material. And if you want to see them, well, pay for them, right? Like, wait a minute. If you're going to rely on them for court, then you got to disclose them. But here, the defense is basically saying pay for them. The request for standardized references is a very general request, as Dr. Orr regularly consults a wide range of resources, including medical journals and reference books. But when the prosecution submits something, the defense wants to know, where did you get that? Tell us where you got it and give us a copy of it. But here, they don't feel they need to do that. So, in other words, this Dr. Orr is giving an opinion or showing a reference to something that she has found in published material, but because she's copyrighted material, she's not going to share that with you, or she shouldn't have to share it because she doesn't remember which book she got it from or whatever. This is just unreal. It's a very general request. Well, no, we're asking in her opinions that she is going to say in court, we want to know where she got those from, right? And just because she consults with a wide range of resources, including medical journals and reference books, you need to tell us where that is in those books so we can see it for ourselves, right? Anyway, she did include a sample of references within her report, a sample, but no, if you're going to get on the stand and testify about something, we want to know where you got that from. And if it's not in the sample of references, then she shouldn't be able to testify to it. Like, that's just like me saying, well, somewhere I heard that those kind of cars blow up. Well, where'd you hear that from? Right? So if I testify in court about, a certain car being prone to blowing up, and I get on the stand and I say, oh yeah, I read that. This car is prone to blowing up. Okay, well, where did you read that? Because we want to see it so we can have our experts go over that to see if it's even a verified source, right? But they don't want to give that. They're just going to give you a sample. And you better take us at our word. No, that's not the way things work. But anyway, typical of Van Taylor. So that's the end of that. So that's the S1 that they fought so hard to keep under seal. Okay, so here we go. So the first part of this, you guys, is going to be, I don't know, a little bit because they got to give a rundown, because you guys know how trials work. They give opening statements, they say what the case is about, blah, blah, blah. And then they go through all their evidence by calling witnesses and this and that. So keep that in mind while we go through this, that they're doing things in the order that they would have done had this gone to trial. So they're going to start with an overview of what they were going to say in their opening statement, and then what they were going to produce during trial. This is 15 pages. Now, this isn't the final, so don't think that this is the final. There could have been things added after this. But let's go. This is what we're here for. Okay, the defendant, Bryan Kohberger. Okay, so after we do the state's trial brief, we'll do the defense's trial brief. And then this is going to be the third order. So we're going to see what documents are going to be coming out next. It's going to take about 3 weeks, but some of these are going to be good. The last two document dumps, you guys, okay, we got a bit, like information wise. I'm not talking about the photos and the videos of the car and all that. That was great. But as far as documents go, these are the ones that are starting to get good. The last two dumps were just basically fighting over jury stuff, over who can testify, who can't, stuff like that. We're going to be getting into some good documents. I'll go over this at the end after reading the trial briefs so you guys know what to expect, what's coming out in the next document dump. Okay, back to this. So, to the defendant, Bryan Christopher Kohberger and counsel, please take notice that the undersigned, pursuant to the court's scheduling order in this case, submits this trial brief in anticipation of trial, which begins July 21st, 2025, with jury selection. Introduction. So, this is basically some of the things that he was going to be saying in his opening statement, but he's just giving an introduction into what this case is about. Good morning, beautiful. Everybody say hello to Unspoken Butterfly. She's just so beautiful. I love it when that picture pops up. Okay, so in the early morning hours of November 13th, defendant Bryan C. Kohberger, a PhD student in criminology at Washington State University, drove his car approximately 10 miles from his apartment complex in Pullman, Washington, to the campus of the University of Idaho in Moscow, Idaho. Defendants circled a house near the UI campus at 1122 King Road several times before he parked his car, entered that house, and used a military-style knife to stab to death the following UI students: Ethan Chapin, Kaylee Goncalves, Xana Kernodle, and Madison Mogan. For this, the defendant is charged with burglary and 4 counts of first-degree redrum. The state is seeking the death penalty if the defendant is convicted of any of the first-degree redrum counts. The trial in this case will tell the story of the defendant's crimes and the investigation that led to his arrest. The evidence will prove to the jury not only that the defendant is guilty beyond a reasonable doubt of all crimes charged in the indictment, but also that given all the relevant facts and circumstances, defendant's crimes warrant the death penalty. The charges and death penalty. The grand jury returned an indictment that charges defendant with the following crimes. Count 1, burglary in violation of Idaho Code 18-1401 and 1403 for entering 1122 King Road with the intent to commit redrum. First degree redrum in violation of Idaho Code 18-4001 to 4004 for the redrum of Madison Mogan, Kaylee Goncalves, Xana Kernodle, and Ethan Chapin. Rose! Hello, hello, hello. Good to see you, Rose. Big hugs. The elements of these crimes are well established under Idaho law and are presented in the state's requested jury instructions. The state has provided notice of intent to seek the death penalty based on 4 aggravating circumstances. So these are the aggravating circumstances that they were going to go with to get the DP, the death penalty. At the time the redrum was committed, the defendant also committed another redrum. The redrum was especially heinous, atrocious, or cruel, manifesting exceptional depravity and or by the redrum or circumstances surrounding its commission, the defendant exhibited utter disregard for human life, and or the defendant by his contact, whether such contact was before, during, or after the commission of the redrum at hand, has exhibited a propensity to commit redrum, which will probably constitute a continuing threat to society. The state's requested jury instructions also cover the penalty phase. Okay? Don't mind me, you guys. I got a holes in my mouth and it causes more saliva. So, give me a break. Okay. The state's case in chief. So, this is their opening statement. Let's see how much more we can learn through this. Now, I want you to pay attention to the case's case in chief. This is their trial brief, right? This is what they were going to do at trial. Wait till you see the defenses. You're going to be shaking your head. Anyway, so pay attention to how they set things out. They're very detail orientated. They're like everything is falling in line here. Solving your accused Slava. I know. It's like the cold's almost done. It's just like it's the end of it, and it's horrible. Anyway, opening statement. There we go, right here. As detailed below, the state's case in chief will involve presenting significant amounts of evidence over the case of many weeks, if not months. We've seen their evidence list. If you guys haven't seen it, I will link that video where we go over all the evidence they had. We went over it all in the previous video I did on this latest document dump. I will link it at the end of this video. I'll link it in the description. Let me write that down because you know I'm going to forget. Link evidence video. Okay. And I believe it's nearing the end of my last video where we go over all the evidence that they were going to be introducing. Oh my God, you guys, it was some parts of that was hard to get through. Pursuant to the court's redacted order governing further criminal proceedings and notice of trial setting dated October 9, 2024, hereinafter called the scheduling order, the parties are required to file a log of objections to exhibits by May 14th. Accordingly, the state should know whether the defendant objects to the exhibits it intends to show during its opening statement and will alert the court through motions in limine or other mechanism preferred by the court of potential disputes so that the court can have the opportunity to resolve them prior to trial. We went through a bunch of those. Witness testimony. The state is currently finalizing its witness list. We went over their witness list and will be inclusive as possible to ensure that it is prepared to establish proper foundation for all testimony and exhibits. The state may not need to call all of the witnesses on the forthcoming witness list as it learns of the defendant's evidentiary objections and the court has the opportunity to resolve any disputes. And this is why I wish they would have started at the beginning of this case, because some of this, what they are saying, we already know the outcome. Okay? We already seen the witness list, and here they say it's a forthcoming witness list. We've already seen it. The judge is going backwards from the latest documents to the oldest documents. And it's kind of pisses me off, because, you know, when they talk about stuff like this, it's like, yep, we already know the outcome of this because it happened after this and we've already seen it. So I wish he would have started right from the, unsealing records from the time things started being sealed and then go through everything so we could kind of follow along and see how things evolved and, you know, what new evidence was coming up and why was the defense fighting it. We're seeing it in reverse order, right? So it's like the witness list, the forthcoming witness list, we've already seen it. Anyway, categories of witnesses. The state's witnesses generally can be organized into the following categories: roommates, friends, acquaintances, and contacts of the Red Room victims. The state intends to call members of University of Idaho and Moscow community who knew or had contact with the Red Room victims at relevant times, including on the night of the Red Rooms. Such witnesses will include the victim's surviving roommates, who are the victims of the defendant's burglary offense, and friends who responded to the house around noon on November 13th, 2022. The state will also call other individuals who had contact with the victims on the preceding days up to the night of the Red Rooms to establish a timeline of events. 2. Law enforcement officers and investigators. The state will call law enforcement officers who first responded. Now, we've seen these videos already, right? To the 1122 King Road The state will also call investigators who were responsible for and participated in the extensive investigation that led to the charges in this case. These witnesses will include officers and detectives with the Moscow Police Department, investigators with the Idaho State Police, agents with the FBI, and law enforcement officers who had contact with the defendant at relevant times, including upon his arrest in Pennsylvania. Forensic analysts and experts. The state will call law enforcement specialists who collectively conducted the forensic investigations in this case. These include those who possess specialized knowledge, skills, experience, training, and education in the following fields: electronic device review and data extraction, cellular data analytics. This is a lot of the CAS stuff, DNA testing and analysts, financial records forensics. This is when they went into all his financials, including, the Amazon accounts and, for certain items like the K-bar, who purchased it, what bank account number or credit card number or whatever. That's what that all entails. These witnesses are primarily employed by Moscow Police Department, Idaho State Police, or the FBI. To the extent necessary, the state previously disclosed these witnesses through its expert witness disclosure list. We also seen that. We seen that in the previous video. Like I said, I will link that video in the description box down below. I'll also put a card at the end of this video that will show up on screen. Family members of the defendant. The state intends to call family members of the defendant for the purpose of establishing certain facts before the defendant moved to Pullman in the late summer of 2022, as well as facts about the defendant's contact when he returned home to Pennsylvania in December. The nature of this testimony has been disclosed through reports of interviews. So, this is going to be in some of the documents that are coming, okay? Because we're seeing everything backwards here, you guys. We haven't seen these yet, although it says here that it's already been disclosed, because we're going backwards. So hopefully, we're going to go through the next set of documents that are going to be dropped, the list that the judge gave. We're going to go through that when we're done the state's brief and the defendant's brief. We're going to go over that list and we're going to see if this is in there. Because I want to know, what do you mean? What do you mean? As well as facts about the defendant's conduct when he returned home to Pennsylvania. What do you mean? I want to know what they have to say. Who wants to know? Rose says, that makes me frustrated because they're trying to lose us in the paperwork. In my opinion, they know exactly what they're doing, but so do we. Yep, we're going backwards. So hopefully in the next set of documents. Now, it doesn't say here when they interviewed them, because if it would have, I would have been able to tell how long we're going to have to wait. Now, how soon would they have interviewed them? I think that they would have interviewed them within a month or two of Bryan Kohberger being arrested. So documents in because he was arrested at the very end of 2022, December 30th, right? A couple days before 2023. So that's going to be in 2023. We're still in 2025 documents. Huh. So I believe that they would have interviewed them back in 2023. So it may be some time before we see these documents, unless those documents are brought up in arguing back and forth. Like maybe the defense doesn't want those documents to come in, right? We might see it a little bit earlier, but we're still in 2025 here. And this is why I'm saying he should have started at the beginning when he got arrested, and then start unsealing documents from the beginning. Because this is saying that they've already been disclosed, but we haven't seen them yet because we're going backwards. Anyway, you know what I'm talking about. Foundational witnesses. The state will be prepared to call all witnesses necessary to authenticate the exhibits it will introduce at trial. This will include calling witnesses who can attest to the chain of custody for physical exhibits, and those who can establish that certain documents are business records and therefore not subject to exclusion as hearsay. Depending on any objections that the defendant makes to the state's exhibits, the state may arise authentication and or foundation disputes with the court in an attempt to streamline the number of necessary foundational witnesses. Considerations and requests regarding individual witnesses. Privacy for testifying victim witnesses. The state will call 2 roommates of the red room victims who were present in the 1122 King Road house during the red rooms. These witnesses were 19 years old at the time of the red rooms. They have been understandably traumatized by what transpired and are victims of the burglary offense. They have received death threats and have been the subject of conspiracy theories and have been harassed online in ways that continue to affect their privacy interests and well-being. The state is concerned that if video of these witnesses' testimony is broadcast on the live stream, individuals outside of court could screen capture images of them and circulate them on the internet in harmful ways. Accordingly, the state is going to request that the court pause the video live stream, but not the audio if possible, during the testimony of these victim witnesses to protect their privacy to the extent possible. The court should grant the state's request pursuant. We all knew who Dylan and Bethany were, so yeah, I agree. The court should grant the state's request pursuant to Idaho Court Administrative Rule 32 and Rule 611A of the Idaho Rule of Evidence. The former grants courts the discretion to adopt trial procedures that provide public access to court proceedings while minimizing the risk of injuries to individuals, protecting individual privacy rights and interests. So I want to also thank you. I forgot who the guy is, but there was, let me just see if I can pull it up on my phone. Because going over these documents, you guys, let me just see if I can pull it up here. I think it'll be here. Hang on a sec, you guys. Okay, so here it is here. I don't want to say, this is why I'm going to show it on camera, you guys. Because I don't want to repeat his name. Let me just see. Let me just see how my camera is. Oh, my camera's not going to show. Hang on. Let me stop sharing this for a minute. There. As you guys can see, I got my handy coffee here. Okay, so it's, I don't know if you guys are going to be able to see this. Okay, so this is his name. You can see it right there. FKU probably. And he did a good comment here. He said that he was watching a random YouTuber about the same amount of subscribers as me. Anyway, apparently she's a former reporter. I'm going to share to you what I said on her channel. The short of it is I just subscribed to your channel because you decided to treat adults like adults and actually go over the documents in full. We've all waited for years for these details, and for this other YouTuber decided to virtue signal, milk the runtime length under the guise of not wanting to share those things. We all know it was horrible. He was a little upset because I've seen a lot of YouTubers, what they'll do is they'll just go like this and they'll take bits and pieces of documents to show you and just fly through them or not show them at all. but I know you guys want to see all of them, right? So, I mean, certain YouTubers run their channels a certain way. That's okay. Whatever, do it your way. So I just want to, in case you guys had seen this, um, but he puts here, this is what he had sent to the other YouTuber. And like, he didn't hold back. You're probably not going to go through all the details. It's why I don't subscribe. And your growth should be limited. I don't understand why you aren't, and I'll respect that. But at the same time, in the context of your platform and your reporting and the audience you want to curate, I think we are mature enough to have a guided dialogue about the details. Instead, we'll end up on Reddit or some other channels. So I did, thank him for subscribing to the channel here. And I'm sorry about, what he went through on the other channel that he is talking about. So I get what he's saying, because a lot of creators, they don't want to take the time to go actually through the documents, right? Like I am. They just go really quick. Like what page am I on? Page 6. They'll just go, okay, look at this, and they'll read this part, and then they'll do this. Okay, now down to this part. This is the part we need, and then they'll go, never mind all that. Da 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 da. Listen to this, and then they'll go da 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 da. Listen to this. So I get what he's saying. Now I got to get back to where we were. Okay, we were here. So I get what he's saying, but I know, especially a lot of you guys want to see the whole document. You just don't want to see what, the creator thinks is important, because there's things in here I don't think are important, but it's because of my legal background. It's just procedure. But for you guys may want to see this so you can better understand how things go in the court system, and how things can be presented and how they can't, and have a little bit more understanding about what exactly they're talking about. Like, why are they adopting certain things, and why aren't they allowing certain things? If we go over the full document, I can more explain it to you. So I hope that um, makes it gives a little bit more depth, I guess, to that person's comment. I did, but I did comment and thank him for subscribing to our channel. And he seems to really like how we go over the documents. So I like to hear that, because now I know I'm not wasting my time, right? Or wasting your time. Nana says a lot of these documents aren't going to make sense until you get to the beginning. Well, that's why I'm explaining a lot of them, and explaining why certain things are in these documents, where it says, well, we've already filed that and you've already seen it. Well, no, we haven't, because we're going backwards. So I try to explain things to the best of my ability. Okay. So the court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence as to make those procedures as effective for determining the truth, avoid wasting time, and to protect the witnesses from harassment or undue embarrassment. Emphasis added. As an initial matter, the state's request does not prevent public access to the witnesses' testimony. The public will be able to hear their testimony, and members of the public who are present in the courtroom will be able to see the witnesses as they testify. This is consistent with the vast majority of trials in the state of Idaho, which are not live streamed. Charlotte says, we want the facts and you give it to us. You break down the documents. Thank you always. You're very welcome. Effectively, the state requests simply prevents the images of the witnesses from being re-recorded and disseminated in potentially harmful ways. So in other words, they just want to cut the camera feed. We would have still been able to hear the testimony if the judge agreed to that. But I mean, the judge also said, you better have pretty good reason not to show witnesses during the trial on the live stream. If they're already out in the public and have been identified, and photos of them have already been out, we all know who they are, then he was not going to do it this way. So I do believe that the judge said in one of the other documents, maybe that was still under seal. I don't know. But I do know that they were going to be shown. The judge had said that their names were out there, their photos were out there. Everybody knew who they were and what they looked like. And that's why they showed Dylan at the sentencing hearing when she read her victim impact statement. Now, Bethany, they didn't. Bethany had somebody else read it, which, you know, that's why I say I think the judge did not allow that, because they did show Dylan, and Bethany, instead of reading her own statement, she chose to have somebody else read her statement for her. So that's how I know that the judge did not allow this request. Okay. Effectively, the state's request simply prevents the images of the witnesses from being okay, we read that. Okay, support for victim witnesses, victims, and young witnesses. To me, young witnesses would be children. So, I mean, anybody under 16, I believe, could be classified as young witnesses. So I don't know why they have this here, because all of these witnesses were over the age of 18, right? Several witnesses, namely the surviving roommates and other friends of the victims, are young people whose lives have been upended by the trauma of the red rooms and the aftermath caused by the intense media attention on this case. Okay, so with the young victims, maybe they are talking about younger brothers and sisters of like Ethan, Kaylee, Xana, Maddie. I don't know if they had younger siblings. So that's, but they're saying young witnesses. I don't know what younger witnesses that they were going to be bringing up. Are young people whose lives have been upended by the trauma and the red drums and the aftermath caused by the intense media attention on this case. So if you do know of young, like, and I'm saying you, to have special circumstances, it's good for shielding them. I think they have to be under a certain age. And I think all these were over 18. So I don't know. It's weird. Some are represented by counsel, and most have family members who intend to attend the trial to support them when they testify. Anticipating that courtroom seating may be scarce, the state asks that the court allow for counsel and family members of these witnesses to be seated in the courtroom when the witnesses testify. The state will provide advance notice to the court and its staff. I'm still not getting it. I don't know who would be very young to testify as witnesses. I don't know. And if the witnesses to me were all over 18, why would you need, I don't know. I'm not going to question it. The state is designating Moscow Police Department Corporal Brett Payne and ISP Sergeant Darren Gilbertson as its advisory witnesses. To a stipulation, the parties agree that these investigators may be present in the courtroom during all witness testimony. Accordingly, the state intends for these investigators to be present at counsel table to advise the prosecutors and assist in trial logistics. Segmented testimony by investigators and witnesses. The state intends to present the testimony of investigators and other witnesses in segments to assist the state in presenting its chosen narrative of the evidence. This will also assist the jury in understanding the progression of the investigation at issue. Pursuant to Idaho Rule of Evidence 611A, the court should allow this procedure to make the interrogation and presentation of witnesses effective for the ascertainment of the truth. There will be no prejudice to the defendant because each time one of these witnesses testifies, they will be subject to cross-examination at that time on the subjects covered in the portion of their testimony just presented. Certain witnesses may also be called out of order to accommodate travel schedules or to allow them to subsequently be present in the courtroom after their testimony. Exchange of witness schedule. The parties are discussing a procedure by which the state would notify the defendant as to the anticipated timing and the order of witnesses it intends to call as the state presents its case in chief. The state is willing to work with the defendant in this way, but will request that the same procedure apply during the defendant's case. Exhibits to be introduced. The state is currently finalizing its exhibit list. Well, we already seen that in the last video I did, and will be as inclusive as possible to ensure that it meets the burden of proof as to each element of each charged offense. The state may not need to introduce all the exhibits on the forthcoming exhibit list as it learns of the defendant's evidentiary objections and the court has the opportunity to resolve any disputes. Category of exhibits. The state's exhibits generally can be organized into the following categories. Physical items. The state will introduce physical items obtained throughout the investigation, including but not limited to items taken from 112 King Road, the defendant's apartment in Washington, defendant's parents' residence in Pennsylvania, and evidence gathered from the defendant upon his arrest. The state will also be prepared to introduce, as necessary, physical samples that were tested by the law enforcement forensic laboratories. Photographs, maps, and diagrams. The state will introduce photographs of 1, the initial crime scene and related searches of that crime scene, the victim's autopsies. See, I'm glad that this is no. Just the description that we went over in the last video. I had a hard time getting through just the description. No. So I'm glad in a way that the victims' families didn't have to see these photos because they would have been in the courtroom, you guys. The search of the defendant's residence in Pullman, search of the defendant's parents' residence in Pennsylvania, and the search of the defendant's vehicle and person. The state will also introduce maps. They ripped his vehicle apart, you guys. They ripped it apart. The state will also introduce maps generated from satellite images to show relevant locations and the defendant's path of travel at relevant times. The state will also introduce diagrams of the 1122 King Road house and the crime scene. Audio and video files. The state will introduce the audio of the 911 telephone call that alerted authorities to the crime scene. In addition, the state will introduce body cam footage of law enforcement officers responding to the scene. And when they responded, the first officers on there, they had their body cameras on and they went in and they seen what was there in each of those bedrooms. Thank God they blurred that out. Body camera footage of a traffic stop of defendants several months prior to the night of the red rooms, surveillance of a white sedan around the area of the crime scene and path of travel following the murders. The state may elect to introduce only portions of the video files for purposes of efficiency. Background records. The state will introduce various records to establish evidentiary facts such as identity, residency, education, and other background characteristics for the defendant and victims. Forensic data. The state will introduce data generated by law enforcement forensic analysts who process evidence in the case, such as exhibits will be used as foundation for these witnesses' testimony as to their findings. Summary exhibits. The state will introduce summaries of voluminous evidence, financial records, phone records, etc., which are admissible under Rule 1006 of the Idaho Rules of Evidence. Considerations and requests regarding specific exhibits. In-life photos of victims. The state intends to introduce one photograph of each of the deceased victims in this case while they were still living, in-life photos, to prove the obvious but necessary fact that they were human beings. So, Criminal Jury Instruction 701, red room defined. The Idaho Supreme Court ruled that the trial court did not abuse its discretion by permitting the state to introduce in-life photographs of red room victim because the photographs were relevant to prove that the victim was a human being and to establish identity. It did not matter that the evidence was not disputed, it was still material and relevant. The state is cognizant, however, of the Garcia court's finding that the prosecution in its case in chief presented testimony that went beyond the relevant background information and called for a witness to describe the positive attributes of the victim. During the guilt phase, the state will endeavor to quickly introduce background facts about the deceased victims, including the in-life photos, without eliciting opinions about them. Physical items. The state will present various physical items as exhibits, including items from the crime scene, items seized from the defendant, and items that were the basis of forensic examination. Example, electronic devices and swabs and samples of biological materials that were tested. To expedite the trial, the state intends to use photographs of these physical items as much as possible, subject to the court's ruling on any objections from the defendant as to authenticity, chain of custody, or foundation. The state will endeavor to raise such issues with the court in advance of trial after it receives the defendant's objections to the exhibit list. Good morning, Norma. Hello, everybody coming in. Graphic photographs. The state necessarily will have to show graphic and disturbing images of the crime scene and of the deceased victims' bodies. The state will be selective in doing so and will not present unduly cumulative exhibits, which means if they took 15 pictures of the way Ethan was on the bed, they're only going to show one or maybe two. They're not going to show all 15. Prior to calling a witness through which graphic photographs will be introduced, the state will provide advance warning to the court and to the families of the deceased victims so that family members can decide whether to leave the courtroom. State also requests that the court pause the video of the live stream and turn off the public courtroom monitors when graphic exhibits are published to the jury. So they were intending, now I think the judge ruled no, that they would cut the live stream, not the audio, but the video part of the live stream. But the other monitors in the courtroom were going to be staying on. So that means anybody in the courtroom they were going to see these photos. Again, as with the testimony of surviving housemates, the state is concerned that individuals could capture these images and distribute them in harmful ways. The court has the discretion to grant this request under Idaho Court Administrative Rule 32A-5-6. The state understands at least one court has adopted a similar procedure in other capital murder, red drum case that was live streamed. Now, there was only one, right? And that was the Daybell case with Tylee and JJ, right? Charles and Tammy. That's the case they're talking about, the Lori Daybell case, where the children, her husband, his wife, were all red drummed. That's the only one that I seen them. They didn't even show any of the live streams, so I don't know. But anyway, self-authenticate. Oh my God, I can say this word. Why can't I say it? Self-authenticate. Okay, records. Many of the state's exhibits are self-authentic. I just said it. Why can't I say it now? You know when you know the word and you just can't say it, it just won't come out of your mouth. Authenticating records. There we go. Where acceptable, the state is gathering, it's because I'm trying to talk too fast, you guys, is gathering record certifications to the support of admission of these exhibits pursuant to Rule 902 of the Idaho Rules of Evidence, and will disclose these certifications to the defendant. To the extent that the defendant still lodges objections to these exhibits based on authentication or foundation, the state will seek to raise them with the court prior to trial to avoid using trial time to resolve such disputes. Demonstrative exhibits. The state anticipates some of its witnesses will use demonstrative exhibits to assist the jury in understanding their testimony and the evidence. The state understands that demonstrative exhibits do not need to be disclosed as part of the exhibit list, but the court's discretion will be prepared to disclose demonstrative aids before they are used by a witness. Accordingly, The state asks that the defendant also disclose any demonstrative aids prior to their use in cross-examination or by defense witnesses. Foundation for cross-examination. We're on page 12 of 15, you guys. Foundation for cross-examination. At the motions hearing on April 9th, the court alluded to the need for counsel to have a proper foundation for questions asked on cross-examination. The state will be prepared to object on this basis if the defendant's attorneys ask improper questions and provides the following case law as support. Ruling that the district court did not abuse its discretion in precluding cross-examination questions where a witness is so questioned without any basis for the inferences in counsel's questions. So they're just giving different cases and how the judge ruled on them. So it's like, just because we have a witness on the stand and that doesn't mean it's a free-for-all for cross. You have to stick to the things that were raised in examination in chief. You can't go off the rails and just start bringing other aspects that you think are relevant into it. You have to do your cross-examination on what was examined on the witness in the first part, right? See here. Upholding district court's decision to preclude cross-examination on a topic without an adequate offer of proof by the defendant's counsel. So yeah, don't go off base. Defendant disclosed 6 penalty phase. Okay, so I'm going to explain this a little bit, you guys, like I always do, because some people say, well, I wish you would have explained that. What do you mean? I still don't understand it. So, like, if all my questions, say we've got Dylan on the stand, and all my questions to Dylan covered, what did you hear? What did you see? What did the person look like? Describe the bushy eyebrows, whatever. If that's my questions, the defense can't get up and say, okay, well, in grade 6, didn't you have bushy eyebrows? You know what I mean? Something totally relevant to what was already brought up in the questioning in chief. You can't go off topic. So I hope that explains it. Or you can't bring up, Dylan, 2 years ago, didn't you shave somebody's eyebrows? You know what I mean? They can't bring up something that was not questioned about in the examination in chief. So that's why they had Dylan and Bethany and Hunter and everybody, all the friends and everything of the victims, they had them on their witness list, their lay witness list, because they wanted to bring up all kinds of stuff about them that they knew wasn't going to come out in chief, right? So I hope that explains it. Okay, penalty phase. Defendant disclosed 6 penalty phase experts on March 31st, 2025 with over 200 pages of reports and exhibits. On April 2nd, the state filed a request for the defendant to supplement this disclosure. We just went over that, right? Defense counsel is in process of doing so. Additionally, on April 8th, defendant made additional mitigation disclosures that may be relevant to anticipated expert testimony regarding the defendant's mental health condition. The state is still digesting these disclosures, determining what experts it needs to consult with, and is in the process of deciding what type of rebuttal expert testimony it will seek to present. The state does intend to proceed with its own mental examination of the defendant and will file a motion for a mental condition examination pursuant to Idaho Code 18207. Now, they are entitled to do that when the defense files anything that they're going to use in their case regarding the defendant's mental condition. Then the state has a right to do its own examination of the defendant. But the defense was fighting that. We end up knowing that the judge did allow the prosecution to do their mental health examination, but only to a certain extent. The state may also need to seek from the court an extension to provide expert disclosures so that its expert can review the defendant's disclosure and conduct needed evaluation of the defendant. Conclusion: the state anticipates appreciates the opportunity to raise the foregoing considerations with the court. It stands ready to address any questions that the court may have and to assist with any procedures the court would like to implement to ensure an efficient and fair trial that protects defendants' rights, the rights of the victim, witnesses, and the families of the deceased victims, the rights of the public and press, and the interests of the people of Latah County and the state of Idaho in achieving justice in this case. So that is basically what. Now there was things added after this, you guys, because the state did do that mental health evaluation on Bryan Kohberger. Like I said, we're going backwards here. So we already know that the judge allowed them to do this mental health evaluation because the defense brought it in. They opened the door to that. So the judge did allow the prosecution to do certain testing of their own on Bryan Kohberger, not all the testing that the defense had done, but enough for them to be able to do a rebuttal, you know what I mean? And have an expert that is going to be able to say, no, he didn't have ADHD. And this is why Dr. Orr didn't want to, and this is just an example, you guys, from myself, what I would be saying. Our expert did do the testing. This is the findings of the testing. This is where it can be found. These are, the documents or journals or whatever that we use to come to this final conclusion. Here they all are. Whereas Dr. Orr is refusing to give us, documentation on where she got this information, how she applied things, blah, 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 what reading constituted that finding. She refused to give us that. We're giving it all to you, So that's what I would have done. And that's what I think the prosecution was about to do. And like I said, you guys, if you go back to my videos, I think it was back in June, I did a video, and the thumbnail, you can go back and look for it. The thumbnail says plea deal coming. That was back in June, long before we ever even knew that this plea was going to happen. Like, we knew, it was like, okay, we're going to trial. We're getting ready to select jury. And it was like, boom, here we go. We got a plea. So it was months before that I did that video. And I said, by the documents I'm reading through, he's going to go for a plea. He's going to beg for a plea. So go back and maybe I will, hang on, let me write that down. I will also, when I'm done this live, I will link that too. I'll put a card at the end of the video up on screen, and I'll also link it in the description. Okay, so you're going to have, the first one is going to be the evidence video, where, you can read it yourself. There was a lot of things I had a hard time reading in that because it describes the victims. And when it got to that, it was hard. So you guys can read it yourself. I will link that video in the description. I'll also put it up on screen at the end. And also where the video I did where it said plea coming. And I said, in my opinion, I said, everybody hears it. I'm saying it on record right now. That was back in, I believe, June. Maybe one of the mods can look it up, but I believe it was back in June. I said, there's a plea deal, and everybody goes, no way, no way. There ain't going to be no plea. There ain't going to be no plea. And I said, well, from what I'm reading, I'm telling you, there's going to be a plea. I'm putting it on record. And sure enough, that's what happened. Okay, give me 2 seconds, you guys. How about we take a 2-minute break? A 2-minute break. So before we go on to this one. Okay. This is the Defendants Trial Brief. So let me put this on screen. Hang on a sec. Why isn't it here? Okay. Nope. Okay. Okay. Let's do that. Okay. So 2-minute break, you guys. It'll give everybody a chance to run to potty if you need to. We've been here for an hour and 20 minutes. Yes. Go make yourselves a coffee. Go run potty if you got to go for a potty break, whatever. Now it just took off. Okay, hang on. There we go. And I'm going to go and heat up my coffee and run to potty really quick. And then we will be back with the defense trial brief is next. All right, I'm back. Everybody back? Nana says, tinkle time. Yes. I got to heat up my coffee. It's good. My first coffee of the morning. I was doing so much this morning, you guys, trying to get all this stuff together. I wanted to do it yesterday, but nothing was working. There was a, what'd they say, AWS? Anyway, I watched a video on it. There was no Snapchat, nothing. Like so many systems were down because they all rely on this AWS, which is Amazon something or other. It's a distribution thing for all. Anyway, I don't understand all that crap. You guys know that. But yeah, okay, so here we go. You guys ready? Is everybody back? Come on. Everybody let me know you're back. Type here in the chat. Type here. I'm back. Let's go. Come on. Okay. So this is the defendant's trial brief. And you're going to see that this is very much it's very different from the prosecution's trial brief. Very different. To me, most of this is just complaining about a lot of stuff. I'm here. Let's roll. Okay, let's go, Rose. Rose says, let's go. When Rose says, let's go, we're going. Let's roll. Okay, comes now. Bryan C. Kohberger, by and through his attorneys of record, submits his trial brief in anticipation of the jury trial scheduled to commence on August 11th. This was filed, you guys, April 14th, 2025. So April, she knew that they weren't going to go to trial. But she wasn't done trying to get the DP gone and evidence thrown out and this and that. And anyway, but she knew he was cooked. Scheduled trial to commence on August 11th at 8:30 a.m. with voir dire commencing on July 30th at 9 a.m. Nana says, let's roll. Let's go. The court set a date of trial briefing before each side has disclosed its exhibits. So they were complaining, right? Given the 68 terabytes of unorganized discovery, here she goes again complaining. If you can't handle this case, you shouldn't have taken it. You should. Anyway, we went over this, you guys. She complained through the whole thing. Look at all this evidence and discovery. Look at all of this. Well, that's what happens in especially a quadruple red drum. Like, what did you expect? Here's 3 pieces of paper. This is our evidence. Here you go. Let's have it go to trial. Like, she knew what to expect. The thing is, she wanted to do everything herself. And there is no way in hell, even on a good day, one person cannot handle a single red drum trial. You need a couple and investigators and all these people to help you along the way to cipher through all this discovery. But she wanted to see each and every page. She did it to herself. You know what I mean? And it irritates me to no end. Like, you knew what to expect. You knew this was a quadruple. You knew how much volume of stuff was going to be coming in. You should have prepared better and not taken on another death penalty case when you couldn't even handle the one that you were on. Okay, end of my rant. Keep that in mind as we go through this. The defense's inability to have it all reviewed, the ongoing disputes over incomplete expert opinions. And the thing is, you guys, the prosecution gave it all to them. Just because you couldn't go through it didn't mean that it was incomplete. It's there. Get your people, hire more people, and go through it because it's all there. So keep that in mind, please, as we go through this. The ongoing disputes over incomplete expert opinion disclosures and whatever exhibits the state lists as those it will seek to admit at trial. This trial briefing is submitted in light of that background. So in other words, she's saying, Judge, keep in mind, they didn't give us all the disclosure in a timely manner. They didn't hand feed us like a baby. This is all of this day. This is all of this day. No, all the videos are going to come in on one file. For all they're going to be dated. And these are the videos of the car. These are the videos of the house. These are the videos of this. These are the videos of that. But they wanted it all in a certain grouping, which the prosecution does not have to do that. Okay? Anyway, it's up to you to put things in order. Anyway, it pisses me off. And the judge did end up going off on her and told her the same thing I'm just saying. In light of that background. So she's saying, Judge, please understand. Look at how much evidence there is. Look at how much disclosure there is. Come on, Your Honor. And the judge said, hire more people. And she didn't. Even after the judge telling her to hire more people to help get through all this disclosure, she still didn't do it. The underlying alleged facts of the case are well known to the court and are not reiterated. Indictment. A grand jury indictment on May 16th, 2023 returned against Mr. Kohberger for the charges of burglary and the 4 first-degree redrum. On June 26th, the state filed a notice, which they have to. They only have 60 days or 90 days. Once the indictment comes through, they only have, I think it's 60 or 90 days to file a notice if they're intending on seeking the death penalty. And they did. They did a month later. Whereas they had 2 months or 3 months, to file this notice. They filed it, May 16th, June 26th. So a month later. The state filed a notice pursuant to Idaho Code 18400, providing the required notification of the state's intent to seek the death penalty. She is. Oh, you guys. Okay. Jury selection. Jury selection set to begin on July 30th will commence after juror questionnaires have been filled out and provided to counsel. And we know what they did with that, right? They screwed with calling people that could be potential jurors and saying things that they shouldn't have brought up and all this stuff. They tried to put a thorn in this from the beginning. The final juror questionnaire is yet to be determined. Well, we know that was already argued, fought about, and decided because we're going backwards. Mr. Kohberger has filed a motion seeking to prevent the use of the magic question and other procedures for jury selection. Mr. Kohberger filed a motion on October 16, 2024, requesting proper voir dire in his capital case. He reiterates his request for individual and sequestered voir dire as it relates to potential juror views on capital punishment as well as case-related information. So what does that mean? What that means is we seen in the Letitia Stout and stuff like that, we seen they bring 75 jurors in at the same time. They ask a question they ask the questions to all 75. If you agree with this question or you don't understand it or you're opposed to it, or if you have something to add, put your hand up. If I ask the question to these 75 jurors, are you for the death penalty? If you are, put your hand up. The ones that have their hands up, they get questioned. If you're against the death penalty, put your hand up. And it's a way of weeding out certain jurors, right? So then they go through all these questions to the whole 75 jurors that are in the courtroom, and then they send them all out. The defense and prosecution can say, okay, we don't want this juror, we don't want that juror, whatever. They combine them together. They get rid of a bunch of jurors. And then out of those 75, they may have 10 that they're going to keep to go on to the next phase. That's how it's done. But what Bryan Kohberger wanted is he wanted each juror brought in individually and go through all these. I think there were 63 questions for voir dire. And they wanted each juror brought in individually. Can you imagine? It would take 2 years to get a jury. Anyway. So, evidentiary issues. And you see here, her trial brief is all just complaining. It's not like what they intend to do during trial. It's all complaining. There is a little bit of what they intend to do, but 90% of this is they're complaining. Evidentiary issues. It is expected that issues surrounding relevance, oh my God, get it together, Willow. Relevance, remoteness, and complete defense will be raised throughout trial. Proof of alibi, alternate perpetrators, and the exclusion of expert opinions due to incomplete expert disclosures will be an issue throughout trial. In the various motions to compel, death penalty motions, suppression motions, and motions in limine filed with the court, many evidentiary issues have been raised. Such evidentiary issues include inflammatory evidence, preventing the introduction of inflammatory evidence such as irrelevant and unfairly prejudicial photographs. What? Photographs of the autopsies? Photographs of the way the house was, how they were found? Right? Testimony and exhibits is the subject of defendant's motion in limine 1. Read inflammatory evidence. Mr. Kohberger contends that his right to a fair trial, free from irrelevant, cumulative, and unfairly prejudicial evidence as guaranteed by the state of federal constitutions, prevents the state from introducing evidence that may cumulatively highlights gruesome exhibits or elicits overly emotional testimony. There it is. They don't want the autopsy photos in there. They don't want the crime scene photos of the victims in the beds and stuff like that. And no. Mr. Kohberger heard the court's comments at hearing with optimism, but will, if necessary, be ready to object and follow with a motion to ensure his fair trial. Excluding experts. They're not happy that the prosecution wants their own experts for rebuttal of the defense experts. They don't want that. No. Just believe our experts and take them at face value. And no. We didn't. No. We don't want that. That might prove something that we're scared. No. Okay. Mr. Kohberger seeks to exclude expert testimony that is vague, undisclosed, and improper. I don't know one expert that gives a vague description of something. Experts are brought in to give you an expert opinion. It's like, look at this, you guys. Do you not find this weird? Expert testimony and expert disclosures have been the subject of several motions, including the defendant's motion to compel material and for sanctions. They were denied. Defendant's motion to extend time to disclose defendant's guilt phase experts. Defendant's motion in limine 2, read vague and undisclosed expert testimony. Like I said, expert testimony is neither vague or undisclosed. They're saying that the prosecution will say, our expert is going to say this, and it's not going to be vague. And you can cross-examine him about what he's testifying about if you still don't understand the concept of what he is trying to explain to you. That's why there's cross-examination. But an expert testimony will not give vague testimony. They go in depth. That's why they're called experts. Defendant's motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. Well, it was found that there was only one violation, not numerous. There was one, and it's because somebody forgot to send that over to the defense. And it wasn't nothing that was really bad, like that would be like a aha moment for the defense. And as soon as they realized that hadn't been sent, they sent it. But the way they're stating it, like Ann Taylor always does, she goes above and into the dark side, and 1800s law and all this crap that she's used to doing. She figures if she gives some word salad that it's going to confuse a judge. No, it's not. It's not confusing anybody, Ann. Anyway, there was one, and that's why she didn't get the sanctions. Mr. Kohberger awaits the court's decision on his motion to exclude expert opinions due to incomplete expert disclosures, and that's only because they didn't find it yet in the disclosure that was sent to them. And depending on the court's decision to exclude late, vague, and undisclosed opinions, these will be ongoing issues throughout the trial. Red drum terms. The use of red drum, red drummer, or red drummed, red drum weapon, and similar forms of the word red drum applied to Bryan Kohberger during the trial was the subject of a motion in limine. She did file a motion in limine, and she says, I do not want that red drum word used in any way, shape, or form with Bryan Kohberger's name in the same sentence. Or you can't say in opening statements when the prosecution gets up and say, we're going to prove that Bryan Kohberger red drummed these 4 people, right? She says, nope, we do not want that word red drum used in any way, shape, or form. If you talk about the K-bar that Mr. Kohberger bought, you cannot say that that was the red drum weapon. You cannot, oh God. Like, you're in a first-degree red drum trial and you don't want the word red drum used? What? Anyway, Mr. Kohberger understood the court's indication that labeling Mr. Kohberger a red drummer would be considered argument, and the proper place for argument is in closing argument. Oh, so you can call him a red drummer in closing, but not in opening or any time during the trial. Mr. Kohberger is optimistic the case will be tried in accordance with the court's statements, but will be ready to object and follow with an appropriate motion to ensure his trial is fair. Oh, God. Right, Rose? It's unreal. Psychopath or sociopath terms. So not only can you not use any of these words and similar forms of this word, we also are going to say that you can't use psychopath, sociopath. If I am in my opening statements and I say the red drums of these 4 college students was done by a sociopath or a psychopath, or you had to be a psychopath to do this to these 4 individuals. What? I can't say that? What? Right? Using the terms psychopath or sociopath, Mr. Kohberger understands the state has no intention of utilizing such labels. Mr. Kohberger is optimistic the case will be tried without the use of such terms. He will be ready to object and follow with appropriate motion to ensure his trial is fair. So she's basically laying down the law. Instead of giving her trial brief what she expects to do during trial, she's setting down her law. This is what I am going to do. And this is what you are not allowed to do. Like, it's like, wow. Like, where is anything that you plan on doing on the defense's side? Other than attacking everything that the defense is going to, that the prosecution is going to try put on. That's normal. The defense is always going to attack the prosecution's case by way of cross-examination every chance they get. So why are you coming out with this? She's trying to set down the law ahead of time as I'm not going to allow this. Do not call him a red drummer. Do not say he was a sociopath or a psychopath. Do not say that the K-bar was the red drum weapon. Ugh. Makes me want to puke. Inconclusive data. Inconclusive data about the statistical analysis from item 13.1, fingernail scrapings, is the subject of the defendant's motion in limine 5. Inconclusive data. Mr. Kohberger has now reviewed the state's newest expert disclosure, and based on the work of both the state's expert and his own expert, he has been excluded as a source of the DNA. Yes, there was some male DNA under Maddie's fingers. Now, that could have been from anything. That could have been from her grabbing, if you remember some of the witnesses at the bar, at the corner club that they were at before the red drums happened. She was very flirty. Some people said she was like grabbing people's face, grabbing people's arms. You run your fingernails, or say you touch somebody's face and your fingernail happens to, go across their face a little bit. You're going to have dead skin cells of that person under your fingernails. Okay. So that was what was found under Maddie's fingernails. male DNA from somebody she had touched. And I believe that was at the bar. Just by, the way that some of those witnesses that were at the bar had described how she was falling over, so she would go to grab somebody's hand or whatever. Her nails could have scraped somebody and got somebody's DNA under her nails. The only other DNA under her nails were Kaylee's. And I'm sure she didn't try and fight off Kaylee, but she'd touched Kaylee in such a way that, her fingernails got some of her probably skin cells underneath her fingernails. The same as probably how the male DNA got there, and her own DNA were under her fingernails. So I hope that explains it a little bit more. Testimony about the lab testing must comport with both experts reviewing the sample and opining Mr. Kohberger is excluded. Yes, he was excluded from those. She didn't have a chance to reach out and do anything to him. She was sound asleep when he started stabbing her. She didn't have a chance to reach out and grab him. Mr. Kohberger understands the state's position to now be that the evidence does, in fact, exclude Mr. Kohberger as any source of DNA in sample 13-1. The sample 13-1 is the fingernail scrapings of Maddie. Testimony contrary to that would violate his federal and state constitutional rights. Okay, why do you got to put this in here? Right? They've already said that they stipulate that Kohberger was excluded. So why do you have to be nasty and put this in here? Right? That's just nasty. That's like pot shots. Touch or contact DNA. Now, she doesn't want touch or contact DNA words used. And a lot of people, like I said in the last video, you guys, there was lots of DNA on that sheath. There was some on the snap, and there was some on the back of the sheath, because it's in the evidence exhibits. And it's just like, to me, contact DNA would be like when you use that to puncture somebody. The contact DNA, to me, and this is only my opinion, to me, how I would see this as, I'm not saying this is law, I'm saying my opinion. Contact DNA is what was left on the knife after it was used on somebody. That would be contact DNA, because it come in contact with somebody that their DNA ended up. Touch DNA is anytime that whoever had that weapon touched it. You know what I mean? That's not how it is, but to me, that would be an easier way to explain stuff. But anyway, just because it says touch DNA doesn't mean that it was a minute amount. The person who was going to testify about how much DNA was found on that sheath, she said, somebody interviewed her, and she said there was a lot of DNA on that. It wasn't just like a speck. There was a lot of DNA that they could have done 20, 30 tests using the DNA that was found on that sheath. So it wasn't just a little speck of DNA found on the snap. There was lots. Enough to do tons of testing. Testimony of Raylene Nolan and any testimony referencing the terms touch or contact DNA, or that purports to be an opinion of the means or mechanism for DNA being placed on the sheath by any witnesses called to testify about the DNA, was the subject of the defendant's motion in limine number 6. Raylene Nolan and reference touch and contact DNA. Mr. Kohberger sought to exclude any use of the language touch and contact in the context of the DNA testing of the sheath and any opinion of how and when the DNA on the sheath was deposited. Well, in order for certain DNA to get on that knife sheath, if his DNA was on it, it had to have been placed there by him. Okay? And I'll tell you why. Because there was nobody else's DNA on there. A lot of the Kohbergers are saying, oh, somebody else could have touched something of Bryan Kohberger's. And then, hang on, I got to sneeze, you guys. Hang. Well, that came out of nowhere. Sorry. Oh, I tried to grab a Kleenex and mute quick, but oh, uh-oh. Hang on. Oh, usually it's only 3 sneezes in a row, but that one was 4. Anyway, in order for somebody else, say, to have touched Bryan's laptop and got Bryan's DNA on their hands, and then they grabbed Bryan Kohberger's K-bar knife and sheath and used it to go there and do these red drums, that person's DNA would have been on there too. There was one DNA, one person's DNA, and that was Bryan Kohberger's. So, thank you, you guys. I don't know if you heard some of it, but I tried to grab a Kleenex that's behind me and then hit the mute button at the same time because you can see my mouse is on this screen. This is my second screen. I have to run over here to my other screen and hit the mute button. So anyway, hang on a sec, you guys. Okay. After sneezing, you know you have to blow your nose, right? Okay. You guys didn't need to hear that. Okay. So she wants that. She doesn't want that to be able to come out, right? In context of the DNA testing of the sheath and any opinion of how and when the DNA on the sheath was deposited. While the court did not enter an order excluding the language, the court's suggestion that it should not be used to avoid confusion and prejudice to Mr. Kohberger is well taken. His objections will be lodged during the trial should the use of the phrase come up. It's like, are you kidding me? People in the lab use this all the time, these words, touch, contact, you know? Anyway, bushy eyebrows. Witness identification by bushy eyebrows is the subject of defendant's motion in limine number 7. Witness identification by bushy eyebrows. Mr. Kohberger sought to bar witness DM from using the words bushy eyebrows or identifying him in that manner. He also sought to keep the state from acting as an identifying witness by attempting to bolster DM's testimony with a photo of Mr. Kohberger taken the morning of November 13th, 2022, and arguing that it is their interpretation that the bushy eyebrows described by DM are consistent with those in the photo. So do you remember that photo, you guys, where they had him in the morning after the red drums? Thumbs up? Well, no, that shows what Dylan said she saw. She said she saw somebody with the bushy eyebrows. We ended up arresting Bryan Kohberger, and guess what? These are the bushy eyebrows she's seen. So it's totally relevant. Should the court allow this testimony and procedure, Mr. Kohberger will object during the trial. God, please don't show the jury anything that could prove that Bryan did this. Please, Your Honor, don't show them anything. Please, Your Honor. That photo describes bushy eyebrows. He's got bushy eyebrows in that photo, Your Honor. Please don't show them evidence of that. Come on now. Now, Bryan Kohberger had shaved eyebrows. What would they do? Well, look at Bryan Kohberger didn't have bushy eyebrows. I'm sure they would introduce a picture of Bryan Kohberger from that morning with shaved eyebrows if there was one. Look at Your Honor. He doesn't have bushy eyebrows. This is like the morning, like when he got up in the morning of November 13th. The red drums happened like 5 hours before this. And look at, he doesn't have bushy eyebrows, Your Honor. They would have introduced it had he not had bushy eyebrows. I'm sorry that you heard that, Rose. I tried to mute as soon as I could. 404B evidence has been the subject of a notice, a motion, and a stipulation, including State's notice of intent using IRE 404B evidence. B, defendant's motion in limine. 8, unnoticed 404B evidence. And C, sealed stipulated agreement of the parties, not to mention 2014 cell phone incident during trial. What is, I'm sure we're going to find out what this is, but I can almost guarantee you that this here, Your Honor, please don't let the jury hear about Mr. Kohberger stealing his sister's phone for his drug use. Please, Your Honor. Please, 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 look at all this stuff against my client. Please, please. Yes, it's true. But please don't let them use it. In response to the defendant's motion to eliminate 8, the state has advised the court and counsel that it intends to comply with the application of the Idaho Rules of Evidence in regard to any proposed 404B evidence. Additionally, in a sealed stipulation, the parties, we haven't seen it yet because this is afterwards. It should probably come out, and that's why I said wait till you see the list of what's coming out next. I can't wait because a lot of this stuff that's sealed here that they're talking about, we're going to see it. Additionally, in a sealed stipulation, the parties agreed not to mention the 2014 cell phone incident during trial. So the prosecution said, okay, we won't tell the jury that he stole his sister's cell phone and sold it for drugs. That incident involved Mr. Kohberger's taking his sister's cell phone to a kiosk at a mall in exchange for money. His father called police, and end result of which was a minor theft charge that was later expunged. The state has not indicated 404B evidence other than a traffic stop. Mr. Kohberger will object and follow with an appropriate motion any other evidence that the state seeks to introduce that is unnoticed. Okay, so also in that traffic stop that they wanted to enter, it showed Kohberger, like, his demeanor and how he treated women, right? Like the questioning of that cop and this and that. But anyway, not only that, it showed the bushy eyebrows and it showed him in that white Elantra. God, please, Your Honor, don't show that, because it shows back then he had the bushy eyebrows. It shows back then he had the Elantra. Gosh, please don't show that to the jury, please. Please. So he's going to object, right? Mr. Kohberger will rely on State versus Whitaker for the proposition that although Rule 404B has its genesis in the common law rule that the doing of a criminal act not part of the issue is not admissible as evidence of the doing of the criminal act charged. Well, it is part of the criminal act that he's being charged with because he's in that car. He is driving that car. He owns that car. That car is part of this court case. Will that fly? I don't know, but that would be my argument. If I was defense, that would be my the prosecution. That would be my argument, right? Anyway, but I'm a bitch. When it comes to that, like, I know where the line is, and I come right up to that line with gathering evidence stuff. Like, there's lines, and anybody who has worked in the legal field know there are lines that are drawn in the sand. Some people stay as far away from that line as they can as to not be questioned to the way they did certain things. Me, I come right to that line. Right, I'm like a hair below that line, but I'm still within the law in what I do. But I'm coming right up to that line, and that's what I would have done. I would have argued that in that way. Yes, that stop shows him driving that car. For this case, proves Bryan Kohberger, one, not only had bushy eyebrows back then. Number two, that he owned that car. He was driving that car. Number three, it was a white Elantra he was driving with Pennsylvania State Police plates. I would have come right to that line. But like I said, I'm a bitch. So when it comes to cases and things I got to do, like you wouldn't want to see me in a bail hearing. I'm telling you. Prosecution did not like me at all because I came right to that line, especially in bail hearings, trying to get somebody out on bail. Now, if somebody did something like this, it'd be like, no, I'm not doing that bail hearing, man. No, not having no part of it. Anyway, the rule expands this evidentiary bar beyond evidence of other crimes. The inclusion of the words wrongs or acts prohibits evidence of contact beyond criminal offenses if it is proffered for the purpose of showing a person's character and conforming behavior. So that's what I did mention. I'm reading this like you guys are for the first time. I went through some of this, but I didn't go through it all because I just got bored at the beginning. But I know you guys want to see all this, so that's why I'm going through it. Well, yeah, you can use this to show his character. I love you too, Caroline. Hello. As usual, late. Well, better late than never. In Whitaker, the court held that 404B is not limited to bad acts. And in State versus Penna, unreported, the same appellate court said that other act evidence to prove a person's character and conforming behavior falls under 404B. Amazon click activity. Excluding Amazon evidence, purchase history, and Amazon click activity, collectively Amazon device evidence, was the subject of the defendant's motion in limine number 9. Now, you know, they tried to get all that thrown out because they said it was a family account and they couldn't prove who ordered what and stuff like that. But then the prosecution went in and found that Bryan Kohberger's personal cards or gift card or credit card were used to purchase that. Because when you go back into the Amazon purchase history, it shows, even though it's a family account, it shows what credit card was used, or a gift card, the number on the gift card was used to purchase that. So if, even though it's a family account, if say Melissa went in and purchased something, it would have her credit card number on it. You know what I mean? So it's very much evidence. So, but they were trying to have all that excluded. And that was their motion in limine number 9, excluding Amazon click activity, evidence at trial. The state's methodology in obtaining, using, and producing Amazon evidence has been called into question by Mr. Kohberger, who contends that this evidence should be excluded. Of course, Your Honor, please don't show the jury that he was looking for knives and sheaths and masks and this and that he purchased it. Please don't show them that. They're going to know that Bryan had it. They're going to know he purchased it. And then tried to purchase it after the red rooms. He tried to purchase it again because, you know what? He lost his sheath. The sheath was at the crime scene, Your Honor. Please don't let them show this to the jury. Come on. So, they're saying that the state's methodology in obtaining, using, and producing Amazon evidence has been called into question by Mr. Kohberger, who contends that this evidence should be excluded. To the extent the court allows this evidence, Mr. Kohberger must be able to present expert testimony of David Howell to provide a complete defense. Based on the court's ruling that this evidence will not be excluded at this juncture, Mr. Kohberger will confront the evidence through expert testimony. He will also object to any expert opinion testimony by Mr. Shane Cox or S.A. Special Agent Michael Douglas, as the state claims they are lay witnesses and not experts. Oh, sorry, you guys. Like, I don't know why all of a sudden I'm sneezing like crazy. If it's not coughing, it's sneezing. It's like, oh. Defense thought prosecution was dumb. Yeah. I love you too. Okay, the IGG, they were still going on about this IGG. The IGG was already done over. We're not going to use it. We're not going to bring it up. We're not going to say that how we got the tip. We're just going to say it was a tip. But they're still bringing it up. Even after the prosecution had said that they would not say IGG, they would not bring it up at all. You poor thing. It's a change in the weather. Like allergies are through the roof again. The furnace now has been coming on. So all the dust and everything that are in the vents. I should have had my vents cleaned before winter, but I procrastinated and I should still actually get it done. But now that's what I think it is too. Along with the change in the weather and hot as hell one day and then cold and damp and raining the next. Um, like from yesterday, it got up to like 73 degrees and today it's 0. You know what I mean? And that's how people are getting sick to begin with. But I'm just getting over this cold. And now my furnace is coming on. So now it's all that dust. So the allergies are kicking in. It's just like I can't win for losing. I can't win for losing. Uh, Part and parcel, I guess. Okay, so I'm not going to read through this. Yeah, my eyes too. My eyes feel like I got sand in them. And that's from the furnace coming on. You guys, I got forced air heat, gas forced air heat. And yeah, I should have had my vents done. But anyway, I'm not going to go through all this. You guys can read through this if you want. I just basically went over it all. That, the state had already agreed they weren't going to use the IGG and all this and blah, blah, blah. And they were just going to say that they got a tip regarding Bryan Kohberger. And that's how they ended up finding out who Bryan Kohberger was. Okay. Vehicle identification. Exclusion of the state referring to all surveillance footage they intend to offer as suspect vehicle number 1 was the subject of defendant's motion in limine number 12. Make and model of suspect vehicle. Mr. Kohberger sought to exclude this evidence pursuant to specific rules of evidence and based on his federal and state constitutional rights. His motion was not directed at the testimony of the state's expert, Special Agent ML, but rather to exclude the state from arguing and other witnesses from saying that all depictions of vehicles were the same vehicle. Based on the court's questioning, Mr. Kohberger must be able to explore with Special Agent ML the year range he was most comfortable with based on the 1125 Ridge Road footage, which videos allowed identification of makes and models, which videos caused him to focus on 2014 to 2016. Oh my gosh, you guys. The sneezing is out of this world. My furnace just come on and the heat vent is beside me. So that's why I'm sneezing so much. So please forgive me. At least I was able to mute myself that time. This is going to be a day, I'm telling you. But it's cold in here, you guys. It's cold. So I had to turn the furnace on. I had no, my hands are freezing. But anyway, okay, which it caused him to focus on 2014 to 2016 years. The actual evidence provides a less clear trail, and Mr. Kohberger, in exercising his confrontation rights, must be allowed to explore Special Agent Emel's opinion. Autism. Here we go. We're on page 7. You guys, we're halfway there. Autism spectrum disorder, ASD. Mr. Kohberger's autism spectrum disorder, along with related issues, was the subject of 3 pending motions. A, defendant's motion in limine, number 13. Conditions as aggravator. B, state's motion in limine, neuropsychological and psychiatric evidence. And C, defendant's motion to strike the death penalty, autism. So he wanted to strike the death penalty. He was going to say, he has autism. There's no way. Like, it's not his fault. No. Mr. Kohberger anticipates that the issues related to ASD will arise throughout the trial with continued effort by the defense to explain ASD and provide defenses related to state of mind. So they're going to say that these things messed with his state of mind and caused him to do that. No, this took planning. This wasn't just I'm sitting there and I'm having an episode and I decide I'm going to bring all this stuff to cover myself. I'm going to grab this K-bar. I'm going to drive, towards Moscow. I'm going to turn off my phone. I'm going to go directly to this house. You just scour it out and drive around it 4 or 5 times. And then I'm going to take the life of these people. And I'm going to exit and drive all the way down south to come all the way back up north to Pullman. And I'm going to go grocery shopping and do. No. Get rid of the sheath, not the sheath, the knife, get rid of all the clothes, bury this, bury that, whatever he did with the stuff. No. What? No, this took planning. Planning. What do you guys think? Tell me in the comments while I sneeze again. Okay, I got tons of Kleenex in front of me. Bless you. Thank you. It's like maybe I'm just allergic to Anne's bullshit. That could be it too, you guys, as we read through this. Anyways. Okay, statistical analysts. Statistical analysts and related testimony were the subject of defendant's motion in limine number 14. Statistical, get it together, Willow. Statistical analysts. Mr. Kohberger sought an order preventing the state from improperly eliciting statistical testimony. Allowing such testimony would violate his federal and state constitutional right to due process, fair trial, effective assistance of counsel, and confrontation of witnesses. What? Why can't you bring up statistics? I've never seen a case where statistics were not brought up. Like, oh God. Like, you can see Anne flipping out here. Like, I got to try and get all this. It's not going to happen, but I got to try. The state has agreed that they will not elicit testimony attempting to relate to the likelihood ratio for the DNA on the sheath the world population. Thank you, Nana. Yeah, it took a lot of planning. This wasn't just he had an episode of one of his mental health things. No, it was a lot of planning. He scouted 23 times. They have him in that area. And you know what, Probergers, if you're listening, why is it then that once these red rooms happen, like you guys say, oh, well, he went into Moscow a lot and he went shopping there and blah, 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 and he went driving and blah, blah, blah. Okay. Other than at 9:30 in the morning when he went back because he hadn't seen anything on social media about these red drums and he wanted to go and check and see what the hell was going on and notice there was no cops or nothing around. Oh my God, I got away with it. Yay. Other than that, he never went. He had over a month to go back and forth to Moscow again. He never went back ever again. So if it was a normal for Bryan Kohberger, and I want your opinions, you guys, am I reaching here? If the Kohbergers are saying it was normal for him to go into Moscow shopping and to get gas and go to bars and do this and do that, then why is it after the murders he never went back again? When he was going there several times a week leading up to the red drums in that specific area, why is it that after he carried out his plan, he never went back to Moscow? Ever. I want the Kohbergers to answer that because their biggest argument was he always went to Moscow shopping. There was better stores there, this and that, whatever. He had a friend there. He did this there. He did that there. Okay. Why didn't he continue doing that until a month and a half later when he went to Pennsylvania? Why did he never go back there again? Ever. Stop it. Stop it. Okay. 911 recording and transcript. The recording and transcript of the 911 call to Whitcomb on November 13, 2022 was the subject of the sealed state's motion in limine re 911 call. Relying on exceptions to the hearsay rule and effect on the listener, the state seeks the admission of both the transcript and the recording. Based on his constitutional rights, Mr. Kohberger objects to the admission of the transcript of the recording. This I agree with. If I was a defense attorney, this is one of, to me, the first valid arguments she has. The first valid. Well, actually the second, because the under Maddie's fingernails, that too. This is only, out of all of these, there's only two valid things she has in here. This I agree with too, based on everybody's, not just his, but everybody's constitutional right. It's up to the jury to listen to what they hear and go by what they hear with their ears on that recording, not a transcript that was transcribed by maybe the prosecution or somebody on the prosecution side. No, they should be able to be given the transcript to just try and follow along, but it doesn't go into evidence. They've got to rely on what they hear with their own ears. So when they go back to deliberate, they can't rely on that transcript. They won't even have that transcript. They have to rely on what they're hearing with their own ears. So that I agree with. Are you happy, Anne? I agreed with you on one thing. Yeah, he planned it for a while. Chubby Eve's Furs. Corey Feldman? I don't know what that means. What are you talking about? Cubby Vespers. Yeah, like, what are you talking about? Oh, wait. As we're waiting for Cubby to answer us, let me just get rid of this so it stops making noise. If he doesn't answer, Nana, just remove the comment. So yes, this I agree. Alibi. Alibi evidence is the subject of various notices, discovery responses, and motions. On July 24th, 2023, Mr. Kohberger filed his notice of alibi. Yeah, I was out driving around looking at the stars on a night where there was ice fog. You couldn't see a star in the sky. It was cold and it was raining. But I was out looking at the stars at a park that no video cameras show you going in that direction. They show you going in the different direction. Cubby, I'm asking why you put this in the chat. Carol, let me check. Your comment disappeared. That's got to be YouTube, Carol. YouTube does delete comments on their own because I don't see it in my studio either. Nana says she was used to getting her way with other judges. This judge stopped her in her tracks. Yes. Yeah. So, Cubby, that's what I am asking you about. Why did you put Corey Feldman in the comments? What's that about? Okay. Pursuant to court order, Mr. Kohberger filed a notice of the defendant's supplemental response to the state's alibi demand on April 17th. They were late. They were late filing it. Previously, Mr. Kohberger's alibi had been the subject of a motion to compel. More recently, the state filed a motion to eliminate alibi. Mr. Kohberger has met his statutory obligation of provide. Met his statutory obligation of provide. No, there should have been two. I hate that. To provide the state notice of corroboration of his partial alibi. Mr. Kohberger stated on record his concern about the state commenting on his constitutional right to remain silent. He will make an appropriate motion should these comments be made in front of this jury. Yeah, but his alibi was, I was out driving around. That's not an alibi. And then she went in to start on, okay, well, that didn't work. So now we're going to try an alternate perpetrator. Alternate perpetrator evidence is the subject of the state's motion in limine re. Alternate perpetrator evidence. Mr. Kohberger anticipates making a proffer of evidence of alternate perpetrators so that such evidence can be properly evaluated for relevancy and admissibility under the Idaho rules of evidence. Well, we already know what happened with this, right? The judge denied the alternative perpetrator evidence. He denied it because she mentioned certain people that were already investigated. Their DNA was taken. They were compared. They had alibis, rock solid alibis, etc. So that's why the 4 people that she tried to say could have been the ones that did this crime were found. There's no way they could have done this crime. So there you go. So we know that this was already denied by the judge. Mr. Kohberger's interpretation of the court's comments is that the persons investigated by the state may be confronted through cross-examination of law enforcement investigative work. Demonstrative exhibits. Demonstrative exhibit, the 3-dimensional model. See, she says here a 3-dimensional model, but then she calls it a dollhouse, right? And this was the $30,000 that the prosecution spent on building a 3-dimensional model of the 1122 King Road house, which is now $30,000 wasted. So much wasted. So much. Because he pled, right? So the demonstrative exhibit of the 3-dimensional model of the 1122 King Road residence, also known as the dollhouse. I don't know who would call it a dollhouse because it's a redrum house of horrors, was the subject of the state's motion in limine re. Demonstrative exhibits. Mr. Kohberger will continue to object to the use of the dollhouse for distinct reasons arising from discovery issues. I hate that she calls this a dollhouse. It's a house of horrors. Specifically, Mr. Kohberger objects to the use of the 3-dimensional model house constructed in an undisclosed way on the grounds that it is irrelevant. How is it irrelevant? It shows the footprint of that house. So when you're speaking to the jury, and you could remove the levels, right? So if you're just talking about the first level, like the ground floor where Bethany was, you could remove the top 2 levels and you could point and show the jury so they could see, like, this is how the house was set up. It wasn't to scale. They weren't using it for that. It was for demonstrative purposes only, right? Just so the jury had an idea of what they were looking at and where Bethany's room was compared to where the front door of the house was, or where the stairs going up to the second floor was, what was above her, stuff like that, right? So for them to say that it's irrelevant is no. Cumulative, because they're going to say they had scans and everything of the house and photos of the house, but this gives an overall view. I don't think it's cumulative. Confusing? How is it confusing? It shows the footprint of this house, right? And misleading to the jury. The judge ended up saying to the prosecution, because we know what happened with this, it was allowed in, but the prosecution had to take the defense team to where it was being built, and it was to be called not to scale reproduction or something like that. So Cubby still has not answered us. So I'm just going to remove the comment. I gave you a chance, Cubby. Okay. Family in the courtroom. It is the subject of the state's motion in limine, immediate family members in the courtroom. Mr. Kohberger stipulated in his brief responding to the state's motion in limine that the individuals identified by the state be considered as immediate family of the victims for the purpose of being in the courtroom during trial. In his responsive briefing, Mr. Kohberger also asked the court for guidance on proper courtroom decorum and guidance on excluding clothing or anything worn in the gallery that supports the death penalty, and asked that Mr. Kohberger's family members have presence in the courtroom. So even though some of them were on the prosecution's witness list, they wanted them to be able to sit in for the whole trial, even though they were on the witness list, which is a no-no. If you're on a witness list, you cannot sit in the courtroom and listen to any other testimony until you have testified yourself. Well, the defense wanted his sister and parents to be able to sit in the courtroom and listen to everybody's, testimony. And I don't think the judge allowed it. The judge said try and get them up quickly so then they can not miss a lot of the trial. But they weren't allowed to sit in from the beginning. And he was going to have a row in the front on the defense side that was just for Kohberger's family. Death penalty. The death penalty and issues related. We're on page 9. You guys were almost there. Death penalty. The death penalty and issues related to the death penalty have been the subject of various motions. Such motions include 13 separate death penalty motions with the topics ranging from arbitrariness to utter disregard. Sealed states motion in limine, improper death penalty comments, defendant's motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations, and the defendant's motion to strike the death penalty regarding his autism. This is crazy. Most of these motions have been decided while others are pending. Mr. Kohberger anticipates that the issues related to the death penalty will arise throughout the trial with continued effort to get the death penalty stricken. Of course, that's what they're trying to do. Self-authenticating records. So the self-authenticating, oh my God, I said this at the beginning. Why won't I be able to? I can't. I'm tired. Anyway, records was the subject of the sealed states motion in limine. The self-authentication of records in reliance on IRE. Please don't use that word no more. They are. In its motion, the state seeks to admit self-authenticating records. The list of records that the state seeks to admit in this manner is lengthy and the volume of data is enormous. So anything that, speaks for itself, basically, and that's kept in the normal line of business. Anyway, Minister Kohberger has objected to giving the state free pass for the admissibility of records that are supposedly self-authenticating. Stop it. Doing this on purpose. After expending extensive time responding to the state's extensive requests for self-authentication. Okay, see why sometimes I can say it and other times I can't. The state abandoned nearly half of its requests. The court noted the motion was not ready for hearing. Mr. Kohberger will make objections and motions as appropriate. Yay. Text messages and testimony. Text messages from Dylan on November 13th, 2022, and testimony of Dylan and Bethany regarding their conversation with each other on November 13th are the subject of the sealed states motion in limine regarding text messages and testimony. Mr. Kohberger contends that the way in which the state proposes using the text messages and testimony presents an incomplete picture. I love you too, Rose. Mr. Kohberger has urged the court to review the state's request with consideration of the complete scope of conversations and cellular phone activity and deny the state's motion. Go away. AT&T timing advance records. This is a big thing that they fought about. In the state's motion in limine, AT&T timing advance records, the state seeks to prohibit the defense from making any reference to the absence of the AT&T timing advance records. We explain this because after 7 days, they can no longer, they're not there, the advanced records, right? They're overwritten after 7 days. It took a month and a half to find Bryan Kohberger and find that he was their suspect. So these would have been long gone. The defense contends that TA reports relating to Kohberger's cell phone exist, at least 7 days of record. Mr. Kohberger has been provided with different explanations by the state regarding the existence of these records throughout the course of his case, including sworn testimony in May of 2024 by Detective Payne. Mr. Kohberger has offered testimony relating to these records based on the explanations presented by the state. The current defense affidavit presented at the time at the in limine hearing is one with more detail based on the shifting state's explanations. Mr. Kohberger has worked with an expert with hands-on experience about TA records. Yeah, Sly, whose software and everything has been declared garbage by multiple judges, and a lot of the states have broken their contracts with him because they found him to be phony. Anyway, that's the guy that the defense hired. He was not allowed to testify and explain what he knew about methods officers use in obtaining TA records. Mr. Kohberger understands his ability to question the FBI agent outside the presence of the jury. Warrants. Warrants have been the subject of at least 13 suppression motions ranging on topics from arrest warrant to the search of Mr. Kohberger's apartment in Pullman, Washington. You're not allowed to search him or his place. Stop it. Well, the court has already ruled on these suppression motions. Mr. Kohberger anticipates that evidentiary issues related to the various warrants will be raised during trial in the form of inconsistent statements or the impeachment of state witnesses. Additionally, the state obtained similar information through the grand jury subpoena process. Mr. Kohberger was prevented from receiving copies of the actual grand jury subpoenas and therefore does not know the scope of information obtained. He will make objections during the trial based on the rules of evidence. Well, you're not entitled to that. The grand jury is secret. Anyway, I believe under certain circumstances they can get parts of the grand jury stuff, but it's supposed to be all in secret. Anyway, we're almost there, you guys. We're on page 11. Investigators in the courtroom. The parties have stipulated and agreed that the defense will have both of their investigators present during the trial, and the state will have its lead investigators from Moscow Police, Corporal Brett Payne, and Idaho State Police Sergeant Darren Gilderson present during the trial without limiting their ability to testify. So they stipulated on that. Yay! Come on, you guys. Everybody in the chat. This is the first thing that they've stipulated to. The first thing that Anne agreed to. Come on, round of applause for Anne. Exhibits. In compliance with the modification of the court's scheduling order, Mr. Kohberger proposed exhibit list will be filed and provided to the state by April 28th. While Mr. Kohberger is making every effort to meet this deadline, all discovery has not been reviewed. And here she goes again. The 68 terabytes. Oh my God, Your Honor, all this evidence and discovery they got, we can't. And overwhelming. The court has ordered the exchange of exhibits to be disclosed 1 week apart. The state's expert disclosures are incomplete and is expected that subsequent exhibits will be identified and disclosed beyond the court's April 28 deadline. Witnesses. We're almost there, you guys. Expert witnesses. Mr. Kohberger had disclosed exceedingly comprehensive expert reports and opinions. The alleged facts are going to be very heavily contested, issued by Mr. Kohberger. Be very heavily contested issue by issue. Mr. Kohberger does not intend to put on a very extensive defense case, but they have 164 lay witnesses. You guys, that's not their expert witness list that I show. They have 164 lay witnesses. I think lay. Anyway, even if they're all combined, 164 subpoenas you were sending out, defense. But you're saying Mr. Kohberger does not intend to put on a very extensive defense case, but you had 164 people on your defense witness list? Come on. He anticipates calling the following expert witnesses to testify at trial, depending on the state's case in chief during the guilt phase of trial. So Ruth Ballard, Stephen Becker, Kathleen Bright, David Howell, Matthew Noel. These are doctors and whatnot. Carol Pedden, Kevin Pedden, Jennifer Ray, who this is the disgraced guy by tons of judges, and his GPS tracking and stuff. Like, if you think you got better shit than the FBI, and that's what he thinks, this is the guy that the judge called out and was going to throw him in the slammer, right? Remember the judge saying, "How dare you accuse the court of this and that?" Or, "How dare you talk to my court staff like that?" Oh, the judge, called him out, flipped out on him. Anyway, his software, all these states that he had contracts with for GPS and cellular data and stuff like that, all the states fired him, and all the judges said that it was finally proven that his software was garbage. But that's who the state called to try and how do you say it? Go against the cast reports, to say that the cast reports were wrong. They were going to use Ray's software. I laughed. Josiah Roloff. I wonder if is he one of the Roloffs from Little People, Big World? I don't know. Eileen Ryan, because that's not a common name. Anyway, Gary Shuttler, Thomas Slavinsky, Brent Turvey, Barbara C. Wolf. Oh, we know who that is. Defendants Trial Brief. Lay witnesses. Lay witnesses that Mr. Kohberger anticipates calling to testify. How many were here? 16 experts. Calling to testify during the guilt phase of the trial will be disclosed by the defendant on April 21st. Okay, so it was lay witnesses, 164. Right? Thousands of trees she killed for these motions. All the trees. Thank God that a lot of this is electronic, right? Okay, so the witness list that we did see in my last video, her witness list, those were lay witnesses, 164 of them. But she says up here that Kohberger does not intend to put on a very extensive defense case. You got 16 expert witnesses and you got 164 lay witnesses. By filing witnesses under seal in compliance with the court scheduling order. To the extent other witnesses are identified as 68. See, she keeps bringing this up, right? The list will be supplemented. Penalty phase lay witnesses will be disclosed by Mr. Kohberger on May 5th. By filing witness list under seal. Investigation for the mitigation phase of the trial, if this case proceeds that far, is ongoing. The mitigation investigation began immediately upon Mr. Kohberger's arrest, but it has been extremely difficult to get teachers, medical providers, families, friends, neighbors, coworkers, and others to speak with the defense. Oh, you hear this? The mitigation investigation began immediately upon Mr. Kohberger's arrest, but it has been extremely difficult to get teachers, medical providers, family, friends, neighbors, and coworkers, and others to speak with the defense. Woo-hoo. Generational records are still being located and gathered. As people and records are located, those will be disclosed and witness lists supplemented. So that was, okay. She didn't tell us anything she was going to do. Except for the two things she agreed on, right? So that's that. Now, do you guys want to let me know in the chat? Do you guys want to go through the next set of documents that are supposed to be unsealed? Because there's quite a few in there that I am really anxious to see. Let me know by putting 1 in the chat if you want to see the next set of documents that are scheduled to come out. Put a 1 in the chat. We got a yes, please. Come on, you guys. 1, 1, 1, 1. Come on. If you guys want to see these documents that are supposed to be coming out next, Norma. Okay, I'm going to scroll through them slow because there's some don't really care because we already know the outcome of them. But I am going to scroll through them so you can see them all. And I will highlight, hey, Fancy Nancy, Shannon's Copper, Fancy Nancy, and Git, and Norma, and Carol, and Nana. Okay. And Norma says, sorry, number one. Number two wasn't an option. That's okay. I knew what you meant, Norma. Okay. So what I'm going to do is I'm going to go through these. Nana, one. I'm going to go through these and I will highlight the ones that I think are going to be very interesting. Okay. So this is going to be the third batch that he's going to unseal. This don't really care because we already know the outcome. And when I say don't really care because we already know the outcome, you guys, it's because we're going backwards. As you can see by the dates right here, 331, 327, we're going backwards. So for the ones that we already have the answers to, especially the questionnaires for the jury, it's boring. Well, I don't want you asking the jury if they're from Minnesota. You know what I mean? I'm not saying that was one of the questions, but you know what I mean. They're boring. We want to get to the meat of it, right? So this one don't really care about. This one don't really care about. This one could be interesting. The exhibits that the defense was going to use in their third supplemental response for discovery regarding expert witness. That is going to be probably interesting. This one is going to be interesting. And as you can see, look at the dates on this side, you guys, right here that I'm highlighting. Watch how the dates go down. So some of these we will already have the answer to, and I will let you know which ones. Defendants Exhibit 1A in support of affidavit objection, state's motion. Yes, this one is going to be interesting. This one here, we already know. Motion in limine 5. This was regarding the jury too. We don't care. These are all going to be interesting. We want to see them. All of these are going to be interesting. This one too. I want to know. I really want to know what this magic question is. So, although I'm not really interested in the voir dire because that's regarding the jury, I want to know what they're classifying this magic question to be. That's the only reason I'm interested in this one here. Okay. The state's proposed jury questionnaire, don't care. We already got the answers to all this. This we've already got the answer to. We just went over it. Remember, I could say this word sometimes and other times I couldn't. Authentication. See? This one, I want to see. Anything with the S1, I want to see. This one might be interesting. It might. Exhibits 1 to 4, I want to see this. Motion in limine 5, that's again with, has to do with the jury. Not really interested in this one. I'll read it and see if it's something more than just, we don't want the jury, we want the jurors brought in one by one again. If that's what it is again, I'm not going to bother. This one and this one. This one is all going to be interesting. This one we already went over. and the judge ruled on it, and that came in. Exhibits 1 and 2 to defense of state motion in limine, read text messages. This one I want to see. This one I want to see. This one I want to see. This one, we've already gone over it. We already got the answer on this one. The judge allowed it in. This one, this one I want to see, and a proof of service is, I'm going to explain to you what that is. Because once I quit working for the lawyers and doing bail hearings and stuff like that, once I stopped doing all the court stuff and the lawyer stuff, I opened my own process serving and skip tracing business. I did small claims court, stuff like that afterwards, when I semi-retired. Proof of service is when you serve court documents on somebody, you have to fill out a proof of service. We call it here an affidavit of service, which means on that paper, it says, I, so-and-so, on this day, by this manner, served so-and-so with this document, the name of the document, the court number, if it's on there, whatever, the day, how you served them, everything else. And then you got to file that affidavit of service with the document into the continuing record. So why this is here and why it was under seal, I don't know. I want to see it. Find out why. This order modifying the no contact order, I think that's when they added Maddie's dad to the no contact order. But we can check it out. The 7th, motion to compel Exhibit A. Maybe. It might be interesting. I don't know. Anything with S1 through S13, I want to see it. Expert witnesses, I want to see it. This too, notice of filing, signed and notarized affidavit. That's like a notarized affidavit. Usually it's an affidavit of service, but this could also be an affidavit that was taken, right? So I want to see what that is. These always spark my spidey senses. Okay, we don't need to, why this was even under seal, because everybody's seen the video of him being pulled over, right? Oh no, everybody heard this is the cell phone, sorry. Everybody knew that he stole the cell phone from his sister. So why this was under seal, I have no idea. I mean, it was already out there. So I don't know why I don't know why it's under seal, but it was. It is stupid. Exhibits 1 and 2 in support. Just, okay, this I want to see. And just because it's here, you guys, it doesn't mean we're going to get it. Because this is going to be one of the doctors evaluating Bryan Kohberger. So the defense, I feel like a lot of these, when I say, I want to see that, they may say, nope, it's to stay under seal because of HIPAA, right? It's regarding his mental health. It's evaluations that were done, and we're not entitled to see that. So I do expect, even though I want to see it, that we're not going to get it. I have got a copy of this list. So once this is released to the public, we'll see if we are able to see it. If it's just arguments regarding it without bringing up specifics, we might get it, but I don't think so. And there's the stipulated agreement again regarding stealing the cell phone. Don't care. The defendant's motion eliminates statistical analysts, not redacted. So we may get that, but it's going to be probably heavily redacted. This motion limit inclusive data, not redacted. We may get, this is just statistics depending on what it is. If it's anything, if the statistical analyst or inconclusive data regards anything regarding Bryan Kohberger's mental health evaluations, we ain't going to get it. Okay? But if it's for something else, we don't know what the statistical analysts or inconclusive data they're talking about, right? The inconclusive data could be about the clippings of Maddie Moog and her fingernails, which we already went through, and they already agreed they weren't going to use it. Statistical, they did talk about that in the last documents, but is that the same thing or is this something else? We don't know. I'll have to take a look at it and we'll see if we get it. If we don't get it and it remains sealed, it's because it's regarding his mental health. This I want to see. I want to see what their argument is. Exhibits 1, 2, 3 in support of motions and limited vague and undisclosed expert testimony. I want to see what that is. Because I don't see any expert testimony being vague. That's why you call in an expert. Now I could see lay witnesses testimony being vague, but not an expert. Never. Okay. Exhibits 1, 2, 3, 4, and 5 in support, excluding IgG. We already know that the IgG and the evidence of that was all excluded. They weren't even going to mention IgG. That was the final ruling, so that don't really care. Exhibit 1, supported motions condition as aggravator. I want to see that. But is that also going to be part of his mental health evaluation? I don't know. We're in February here of 2025, you guys. Exhibit 1, support motion. Okay, this, I want to see their argument. I want to see their argument. Trying to get out the Amazon click activity. And we all knew about that. So why is it under seal? I don't know. This too, support their motion in limine regarding using these words. I don't know why that was under seal. Like, why? I don't know. It's just stupid, you guys. Like, some of this stuff, it's like, why is it under seal? Like, putting things under seal is a last resort, and it's specific. So it's like there's rules for sealing stuff. And I don't know how that falls under the rules. Okay. Witness identification by bushy eyebrows. I want to see that. I want to see their argument on it. Self-authentication of records. We already went over that. That was decided. They were all let in. I want to see this. Exhibit S1. Want to see that. That's all about Bryan Kohberger and, immediate family members. I want to see what that is. I want to see this one. Transcript of hearing held. I want to see that one because we weren't allowed to watch that one. Proposed redactions to the transcript, the closed hearing. We seen this. So why is it here? I don't know. Because the judge did say, okay, listen, remember we got to see half of this hearing, but they closed part of it. And then the judge said, nope, redact the parts that you don't want them to know about, and we're releasing it. So we did see that. So we don't need to see it again, but I'll check it out just to be sure. Exhibits continued to state's rebuttal to defendant's supplementary discovery response expert witnesses. I want to see that. Exhibit to state's rebuttal of defendant's supplementary response to request for discovery regarding expert witnesses. I want to see that. Anything S1, I want to see. S1, I want to see. Exhibit list log. That might be interesting. Exhibit U to defendant's 20-second supplemental request. And you guys are going to start seeing all the Kohbergers. They're saying, look at all the requests for discovery they've had to make. Look at that. They're on 28. Well, you're going to see how stupid some of these are. And then the response by the state, like, you guys got it. It's on disc 10. You know what I mean? So just because they put a request for discovery doesn't mean that they don't already have it. They just haven't seen it yet. It's in their discovery, but they can't find it. Well, get people to start looking through it. Anyway, State supplementary response to request for discovery regarding the penalty phase. I want to see that. This I want to see. Exhibit to defendant's supplementary response to request for discovery. They sent it over again. Here you go, since you can't find it. Defendant supplementary response to request expert witness. Like, this is crazy. Court minutes. This is going to be stuff that's going to be heavily redacted because it's stuff that we haven't seen. Defendant supplemental witness list for motions hearing. Witness and exhibit list disclosure for the hearing. This stuff, I want to see all of this. Subpoena, I want to see it. Out-of-state witness testifying via Zoom, I want to see it. Exhibit A, I want to see it. This, yep. Yep. So a lot of this, you guys, I want to see. So a lot of this is asking for it and then giving it. So I'm not going to show both when we go through this. If we get it, I will just show that they got it and what it is. Because some of this is like here. You wanted this expert disclosure. Here it is. So I won't show this, but I'll show you guys getting it, right? No contact order, proof of service. No contact order, proof of service. I don't know why that was sealed. Order modifying amended no contract, multiple subpoena. I want to see that. Exhibit T. I want to see that. Exhibit A. I want to see that. Exhibit sealed. Exhibit to states. Yes, I want to see that. Material for sanctions. I want to see that. That's going to be interesting. So there you go. So we got 179. Let's see where the beginning is. We've got almost 100 documents that are going to be unsealed. About 90. But out of all of these, we may not get some. Because if some of these sealed documents are anything to do with the mental health evaluations and stuff like that, and a lot of them are the request for something and then the other side giving it. I'm not going to show you each and every request unless it's one that was denied, because usually the request for something is there and then the document follows that they requested. So I will just show you the document itself instead of the request for it, because we would be here for a week. Carol, these ones aren't released yet. This is the third order seeking parties' position regarding the sealed documents, which means Ann Taylor has to go through all these documents now and see which ones she wants to remain sealed. That the judge will make a ruling if he grants that. If he grants it, then there's going to be records that we don't ever get to see. And other records, if she agrees with them being unsealed, they would have to, some of them would have to be redacted. So they would have to go through every document and redact certain things like personal info, social insurance numbers, telephone numbers, stuff like this, stuff like that, addresses, stuff like that. So it is going to take, this was filed, the judge did this on October 16th. They have, the parties are to file their response, including any notice of non-objection, if appropriate, within 14 days of the filing date of this order. So they got 14 days to go through this and send back to the judge a list, which they will do. We've seen how the lists come back. Now, I'm just saying hypothetically, right here, right now, hypothetically, Anne could look at this and say, nope, I don't want this unsealed. Nope, I don't want that unsealed. Nope, I don't want that unsealed. This can be unsealed, but I got to redact it. She's got to go through each and every one of these, as does the prosecution. If there is one that the prosecution says it's okay to unseal this, no redactions needed, and the defense disagrees, then the judge has to make a ruling on it. The judge will decide how it's released. So that could take more time. So they've got 14 days, and then it usually takes another 10 days for the judge to go through their responses and make a ruling on what's going to be released and what's not going to be released. So just because it's on this list, all depending on what the defense says and what the prosecution says about the release of these documents, then we get the final list. The last list, there was like 80 something documents. We only got like 48, I think. The rest remained sealed. And a lot of them were in regards to mental health evaluations and stuff like this, or I don't know. I don't know. So there we are. I hope you guys are happy with what we have gone over. I showed you what we have to look forward to in probably a month's time. And at this rate, you guys, we're only at the beginning of 2025. We got all of 2024 and all of 2023 to get through. And I wish he would start at the beginning. But we're going backwards through the documents. So like after these documents I just showed you, they'll be released probably in about a month's time. After that, we'll be into November and December of 2024 documents. And then we're going to be going backwards to January 2024, which is ridiculous. I wish he wouldn't start at the front, but that's not the way he chose to do it. Have the days passed for him to appeal? I forgot the date you gave us. Yes, but there are still other things that he could still do regarding appeal stuff. He could have entered his appeal under seal because they have more investigation to do. They could be waiting for the ongoing investigation to conclude because there are still ongoing investigations. There's still things that he could do, you guys. Right? Like I said, I don't see us getting all the documents until probably the end of 2026. I don't know. By the way it's going, it's like a month and a half. Well, it took them 3 months to give us the latest documents, and there wasn't a lot of documents compared to 2023 and 2024. It seemed like there was like 10, 15 documents a day being filed. Like there are hundreds of thousands of documents for 2024. Like, so for 2025, and this is just hypothetical to give you an idea of how many documents. So say in 2025, there was like 5,000 documents filed. In 2024, there's going to be like 30,000 documents filed. You see the difference? And you see how long it took for these documents to all come out for just 5,000? Can you imagine for 30,000 documents? So it's going to take a while. It's going to take a while. It's going to take a while, you guys. You're very welcome, Nana. And Norma, you're very welcome. So I do believe, Vera, that he could have filed under seal, is one. And two, they could have filed an intent to put the court on notice that they are filing an appeal. But until they have all the information back from the investigations that are going on, that they have a right to extend that, right? We won't know about that. So we'll see. But I know he's got something up his sleeve. Carol T says, that's okay. I'll have a senior care nurse turn it on for me. Oh, I love it. Okay, you guys. So with that being said, I'm going to wrap it up for you guys here. Get back to your day. I'm such a procrastinator when it comes to certain things, you guys. I don't know. I got so much to do. I got a list of to do. I've got to go and renew my driver's license and my health card because my birthday's coming up. So I got to go and do that, which means like for my health card and my driver's license, I always make sure my hair is nice and I got a little bit of makeup on or whatever. Um, I don't feel like putting makeup on. But anyway, I've got that to do. Um, I've got to get my snowblower out of the shed and get oil in it and fill it up with gas and make sure it's brand new. I just bought it at the end of last winter, so it should be good to go. But I got to get it going and make sure it's starting good and everything else, that I don't have to siphon the gas. I did put a stabilizer in it, in the gas for the summer, but just to make sure it's all good and ready to go. And it's got an electric start on it. It's a gas snowblower, but it's got an electric start, which is good. So I don't got to pull on that to start it. Just to make sure that it starts. Git says, thank you, Will, and happy birthday. My birthday's not till December 4th, but they want you to renew your license and get it in because it takes 6 to 8 weeks to get your new driver's license in the mail. So they always want you to do it 6 to 8 weeks before your birthday. My birthday's not till the 4th of December. But thank you. Nope. My birthday's December 4th. Carol. So I'll have a birthday show for you guys. Yeah, so I've got to get that done. Nana, it's not my birthday yet. It's not my birthday yet. It's not my birthday. December 4th. That's what I'm explaining, that they send the request out for you to come in and renew your license and health card, because you got to have your picture on it 6 to 8 weeks before your birthday, because it takes that long for them to get it and mail it and you get it and whatever. Yes. I'm 22 with 40 years experience. I will be 22 with 40 years experience. It was funny because I was at, oh my gosh, Canadian Tire. I went to get the stuff for my lawnmower and stuff and everything. And there was a guy I was trying to find stuff. And I said, well, at my age, I have a hard time seeing my hand in front of me. He says, what do you mean at your age? What are you, 45? And it's like, oh my God, are you married? Because I love you. I'll be 62 this year. I have to do the same thing, Rose says. My birthday's in December 22nd. I'm going to write that down, Rose. December 22nd. B-Day. I'm getting it on my calendar. We just celebrate up to the day, right? Let's just celebrate from now until then. Every year, my wish for the year is to make it to my next birthday. That's my New Year's resolution, because my birthday is at the end of each year. So my New Year's resolution is to make it to my next birthday. Oh, gosh. And it's weird. Like the last 4 or 5 years has been weird, because I used to drink like on the weekends, Friday, Saturday night, we were out at the bars dancing, drinking, having a great old time. And I don't do that anymore. I haven't drank, well, other than having a glass of wine like at Christmas or Thanksgiving. And I don't even finish that one glass. I quit drinking like 5 years ago. Like no more, like, and it's like, aren't you coming out this weekend? Nope. No. And you know what? I remember less now. I get sick more now. And I told the doctor, I says, yeah, because I don't got that alcohol going through my body, cleansing everything and killing all the bugs and everything out of my system. He starts laughing and laughing and laughing. Not funny, Doc. But yeah, it's just weird that I'm not going to go out and get drunker than a hoot owl. You know what I mean? Yeah, it's been, and I don't even crave it. You know what I mean? I thought that it would be really hard. The first month was hard because I was so used to Friday, Saturday nights going out with the girls or whatever, going campfire or the campsites and drinking and this and that. I don't I don't even miss it. Now I see other people drunk and it's like, "Oh my god, did I look like that? Was I was I oh my gosh." Yeah, no wonder people got pissed off at me when I drank Mel. Um, Everybody thought that I was hilarious when I was drinking. I guess I was really funny when I was drinking. You never knew what was going to come out of my mouth. I fell a lot. I tripped a lot. I did some aerobics, tripping over something and still holding my glass up, saying I didn't spill it. I could tell you some pretty good stories. Almost falling in the campfire one night. I was on crutches because I'd messed up my knee, and I thought that I didn't need the crutches no more. And thank God my daughter's boyfriend was there to catch me, or I would have went face first into the fire. Oh, some of the stories, but I don't miss it. I like to relax once in a while. I never went out to drink. Yeah, I have trust issues. Yeah, yeah, me too. At the bars anymore, like people are getting their drinks spiked and stuff like that. Yeah, no. I remember going out like in my 20s and early 30s every weekend, going out to the bar with all the girls and everything, and leaving our drinks at the table and going like across the room to the dance floor and dance away. You didn't have to worry about stuff like that. But now, oh my God. Yeah, me too, Carol. I used to love everybody when I drank. Even if I wasn't a fan of you when I was sober, I loved you when I drank. I buy rounds of drinks for my table, the table beside me. Hey, and you guys too, because you look cool. My bar tab one night, no word of a lie, you guys, was 700 and some odd dollars because I just kept buying rounds of drinks, and my friends finally stopped me, and they told the waiter and the bartender, "Don't get no more rounds." If she says get a round, don't do it. People sometimes had 3, 4 drinks waiting in front of them. I just kept buying round after round, and it's like, "I did that? Oh, well. Easy come, easy go." But yeah, it was fun. It was fun. Okay, so with that being said, totally off topic. We're gonna wrap it up, and anything new comes out. Don't forget, you guys, November 3rd. Um, we've got Barry Morphew. I'm gonna be covering that. He is. Let me just see here. I don't think we have anything till then. Yeah, Barry Morphew is back in court at 3:30 Eastern on November 3rd. And thank God it's in the afternoon because in the morning, my Jeep is going in to get new belts, new windshield wipers, an oil change, and my snow tires. My summer tires taken off and my snow tires put on. And then the 6th is when I finally get to go and see my specialist, you guys. So I am not going to be online at all on the 6th, and I may even stay out there overnight. I don't know. But yeah, so November 3rd. And also on November 3rd, you guys, is oh, there's another case. Which one was it? Oh, the one with the baby that she said that she was in the parking lot and she got punched in the face and they stole her baby. She is in court, and so is he. He's going to be sentenced, and she has a preliminary hearing. So that's also on the 3rd. I can't cover both. They're both in the afternoon. I can't cover both. So sorry about that. But I will be covering the Barry Morphew. And maybe I'll even have Martin with me. And we'll see. And maybe even my brother, if Kurt wants to come out, we'll have him too, hopefully. So yes. So thank you, mods, for being here. You guys are awesome. Best mods ever. I have not changed my mods since I started this channel. That's how good my mods are. That's how good they are. And that's the family connection we have. They are awesome, you guys. You see other channels, they go through mods like crazy, constantly changing and getting rid of some, and mods turning on the creators and stuff like that. I don't have that issue. I have the best mods around. Yes, he pled guilty, Carol. Baby Harrow, yeah. Jake Harrow pleaded guilty, and she still pleaded not guilty, and she has a preliminary hearing. So, he had no choice but to plead because it was going to be very bad for him. How's that going to affect her? Is he going to put it all on him and that she didn't know? But yeah, you knew because you said that the baby was stolen from you. So that ain't going to work. But anyway, we'll see what happens there. Okay, you guys, thank you for being here. It's 1:45 Eastern. Hopefully you guys enjoy the rest of your afternoon. It's getting a little warmer here. It's up to 7 degrees. I almost want to put my bathing suit on and go for a swim. Just kidding. Just kidding. Okay, you guys, take care. I'll keep an eye on the records. If anything new comes out, you guys will be the first to know. I'm waiting to see if there's another hearing that's going to happen in the Bryan Kohberger case because Anne filed a motion because Bryan Kohberger doesn't want to pay all this new money that the prosecution is asking for. So I don't know if the judge is going to call a hearing on it. If they do, I'll be bringing that to you. So, okay, with that being said, let's wrap it up. I'll end it like I always do. Please take care of yourselves. Please stay safe. Always be aware of your surroundings. I love you guys to the moon and back. Till next time. Mwah!